30.
You are on item number?
46.
Have you informed the
My lordship, consent of the CBI has been taken.
with the consent of the counsel for the respondents, comma, the learned counsel for the petition has submitted that the matter may be taken up on
30th of March.
30th of March. It's to list accordingly.
Obliged, my lord.
Yes.
Please, Your Lordship, I beg to mention item 29. Your Lordship, the case diary had been called for and the same is not available.
The case diary called for is yet to be received. List again on
Interim is there,
Your
madam,
Lordship,
19.
interim may be continued and
19 madam.
19th of March. Interim protection granted earlier continues.
obliged, Your Lordship.
Yes.
Criminal appeal 46, 2040.
While maintaining the conviction of the appellant, his sentence is modified to the period already undergone, with further directions that he shall pay a fine of rupees 50,000 in default to undergo simple imprisonment for 3 years. We have not changed the conviction, just made it into the fine. You were not there in the matter, I suppose. This was one where one single blow during a street fight resulted in a death in 2001. Now, 25 years later, why should we send him again to 304 part 2 is what Planet Court had held. Yes.
Please, your lordship.
Yes,
Matter
sir.
relates to my lord GPay, that wallet.
Uh-huh.
Respect to other co-accused, matter is fixed on 10th.
Ah.
CD may be called for and matter may be
The
fixed.
CD is already called for in the other matters. List the matter again on the 10th of March along with
Date DA number 555 of 2026.
where the CD has already been called for.
Please, Your Lordship.
Yes, sir.
This is a case under section 22C of the NDPS Act, where charge sheet case. Now, what happened from the charge sheet and as well as from the FIs appears that on the basis of the co-accused, he has been implicated. That's not happening.
Call for the TCR, huh? We'll call for the TCR
There's a
shortly.
of our apex court that is in the look, that is Tufan Singh. Constitutional bench, that says that co-accused statement cannot be recorded.
Now, on the basis of co-accused, you were arrested.
They arrested.
Now, what is the other material fine? What is the other material which is?
Suppression before policeman.
No, if there is some other material, we do not know. So we'll call for the.
Yes, that can go.
We'll call for the scan
Yes,
copy.
yes.
Have it on. Yes, when can you have it? When can we have it? Call for the scan copy of the TCR.
17.
Huh?
17.
17th of March.
Wait.
Wait, please, Your Lordship. Your Lordship, anticipatory bail NDPS matter,
Ah.
wherein Your Lordship, same connected FIR, CD has been called for tomorrow in item number 36, Your Lordship. May I fix?
List. Again on the 6th of March.
For six-
Along with
Along with daily list item number 36, AB 354 of 2020.
AB 354 of 2025.
2026.
2026. Where the CD has been called for.
Fiction
Connected matter was.
tomorrow.
Deep fix.
Oh, okay, fixes. Item 36.
Lordship is an application for notice summoned to the accused person by pre-wildlife offence report on the basis of pre-wildlife offence report. And same was issued on 21/2/2026 to appear the accused person on 27/2/2027, but their failure, that's why they have come to this honorable court for.
No, what happened? They received a notice.
Yes, Lordship, to appear before the investigating officer,
Ah.
but they could not appear with the same. As four persons was already arrested in this connection for offense in this crime.
After they were issued the notice.
No, before.
Before they were not issued notice, they were simply arrested.
No,
The other
they were simply
persons?
arrested.
Huh?
They were also arrested directly, Lordship.
Directly, no?
We are ready to appear before the IO, Lordship, but we have some need protection.
The wildlife person is not here. Get someone, get the standing council forest. We'll see. Ask someone from the forest department to be here.
Yes,
Dixit Gogoi is there.
আচ্ছা হেৰি কৰকচোন এইটো এটা স্ক্ৰল এটা দি দিয়ক আইটেম কিমান 4 আইটেম 4 standing council forest will দি দিয়ক
4, 5 also.
after some
4
time
and 5.
after
4
some
and
time
5.
But
Malad, little Malad correction in item 33 already mentioned by Council Malad.
yes, Lordship.
Here, Malad, some mistake is Malad, already we have said that PCR has been called for, but it should be CD. Malad case, there Malad wrong file has been given to us because of that.
Okay.
Malad.
item 30
33.
33 it should be CD huh not
CD,
TCR
CD 19.3, all same.
others remain the same instead of the TCR just keep it as CD huh Ah,
M6. Make digital Lordship, Malad.
yes
Malad, here I have challenged the FIR, Malad. FIR file on Malad 2/5/2025
Mm.
is at page 72, Malad.
72
Yes, Malad. For a check period of 2021, 5 to 2021 to 21/3/2021, Malad. On the basis of 2 inquiry reports, Malad. That I must submit, my lord, that on the basis of the inquiry report, my lord, the petitioner was dismissed from service,
Hmm.
and I challenge this order of dismissal, my lord,
Hmm.
before this honorable court.
Ah,
Dismissal order is page 42, my lord.
page 4 no the what was the order of this court
Yes, order page 44, 27 to 2025, my lord.
ah
Now, Lordship, kindly see para 5. This is the initial inquiry report obtained behind the back of the petitioner without hearing him.
para 5
Para 5, my lord.
of that order
Yes, of that order, page 46. It is the case of the petitioner that he was not
Ah.
afforded any opportunity to present.
Seen.
Yes.
we have seen that
Now, my lord, kindly see at paragraph 14. Insofar as the so-called notice 13/6/2022 is concerned. Page 53, para 14, my lord. It is no doubt correct that the said notice can treat it as a notice
Okay.
initiated. My lord, these two notice on the basis of which affair was lost, having been interfered by this honorable court with a direction, my lord, para 17, while setting aside the termination and interfering with the impugned, my lord, inquiry, my lord, directed for a fresh inquiry within a period of 6 months. Now, order is, my lord, this judgment is of dated 27 to 2025. My lord, without.
just a minute 1/3/2025 what happened thereafter
My lord, they have issued the subsequent notices. That notices were page 57. I put a challenge
then?
before this honorable court without following the observation made in the earlier writ petition, my lord. This notice have been issued
just a minute
and
just a minute 1/3/2025
subsequent.
6 months let it be 1/9/2025 huh
My lord, subsequently, they have withdrawn this notice, page 61, my lord. There was a deliberation of some certain at some length with this notice in the WPC, my lord. 3475 at page 62 is the order. And since they have withdrawn, the writ petition was closed. My lord, granting liberty for fresh inquiry. Now, my lord, subsequent notice was also issued, page 64.
Hmm.
My lord, I have challenged this notice before this honorable court, page 70, directly, lordship kindly sees order dated 6/8/2025.
how we are looking at
Page
that
70, my lord, third paragraph. It is, my lord, second paragraph, in fact, it is the submission of the learned Senate Council for the prisoner without considering his explanation is directed
Okay.
No opportunity in the first initial inquiry. So therefore, that notice has been stayed.
Hmm.
Now, my lord, without getting the fresh inquiry report or without waiting for the fresh inquiry report, my lord, after passing the judgment by this honorable court on 27 to 2025, they have lodged the FIR on 2/5/2025. My lord, I have stated just to oust me from the fray of promotion, my lord. I am at the top in the seniority list, my lord, for the post of, my lord, additional CPT.
Hmm.
They just want to, my lord, just one second. So,
Page 56.
yes. My lord, I am at the top, my lord. My
Hmm.
lord, whether, my question is that, my lord, whether without waiting for the fresh inquiry report as per the judgment 27 to 2025, lodging of FIR subsequently on 2/5/2025, it amounts to, my lord, rewriting the judgment of the honorable court. Therefore, I state, my lord, this is a contemptuous act on the part of the, my lord, respondents initiating the, my lord, lodging the FIR. Had it been lodged, my lord, immediately after getting the, my lord, first inquiry report in 2023, my lord, 21 to 2023 was the inquiry report.
The inquiry proceedings were interfered with.
Interfered,
Then the next show cause notice was interfered with.
my lord. Third was stayed.
Then third was stayed,
Yes.
but there was no fault found with the preliminary inquiry.
Fault found, my lord. Therefore,
Where is the preliminary inquiry fault?
yes, page, para 5, my lord.
Para 5 is a submission.
Yes,
Show us the finding of the court.
correct.
It is the case of the petitioner.
My
Is
lord,
it
yes,
not?
kindly see, my lord, para 14, it is, second line, it is, however, this
Just a
court
minute,
has
just a minute.
notice, my lord.
Just a minute, we need to.
Para
look at the
14.
page. Just a minute. 12.
Yes, 53, lordship.
This is a show cause.
Yes, now, my lord, kindly see page 53, second line, however, this court has noticed that before initiating such departmental proceeding, the petitioner
there
was
is nothing.
not.
There is nothing against the preliminary inquiry.
Yes, my lord, it is there, my lord. Kindly see, my lord. However, lordship found a para 14 second line.
Yes.
This court has noticed that before initiating departmental proceeding, petitioner was not given an opportunity to explain his conduct.
Ah.
The failure of the departmental authority to give an opportunity to the petitioner explain his conduct.
Hmm.
In the considered opinion of this court indicates that
There are some stages. The first stage would be a preliminary inquiry where you are not required to be given a hearing. Then would
yes.
come a show cause notice that this is what we find.
My
What do you have to say? You would
Yes.
say I am innocent. Then would come the departmental proceeding that we are not satisfied with the result or with the reply. Now this show cause notice, which was after the preliminary inquiry, was not given to you. They gave you a show cause saying that, okay, we are starting a departmental proceeding.
My lord.
Court said no.
No.
Before you start a departmental inquiry, you must give him a show cause as to what is your stand.
Correct, my lord.
Therefore, this repetition was allowed on one of the grounds was that.
One of them.
Now, nothing wrong with the preliminary inquiry. Now, if nothing is wrong with the preliminary inquiry,
Yes.
they are sending that inquiry to the police authorities.
Yes.
What is wrong in that is what we are asking
He
you.
also cooperated with the investigation. I have, my lord.
Ah.
Now, lordship, kindly see, unexplained delay, even if we,
Of what?
my lord, even if we say
No,
that
no.
this affair, then affair could have been lost immediately on the getting
That
the
would-
first
that-
inquiry report, my lord.
That would be a ground for you to fight for an acquittal.
Yes,
That there are delays and this and that. But do we interfere in the delay part in a WB criminal?
because, my lord, if it is, everything is malice, my lord, then, my lord, yes, lordship. has
Yes, your
fixed the
affidavits are not coming up.
first
Is it
time,
the
my
first
lord.
time?
It's the first time, my lordship.
And
We have already filed an affidavit in the earlier petition, which we have challenged the second show cause notice.
third.
We have
The
filed
third notice.
the third notice. We have already filed the affidavit.
Third
and
notice is still hanging.
Still hanging.
Yes, Mr. Goswami.
His primary case is that the preliminary inquiry report has
Hmm.
been interfered with in the departmental proceeding.
It is not.
It is not.
It is not. We understand that. We have discussed.
Because the disciplinary proceeding was definitely actually
Hmm.
based on a preliminary inquiry report.
Ah.
So it was set aside, the disciplinary process, but inquiry report it was never set aside.
Now he's taking up the ground of delay.
Delay.
He's saying that the lodging of the FIR after the findings in the preliminary inquiry, trying to set up a disciplinary proceeding,
More than
not
3
going for an FIR at that point of time, Now with the second notice stayed, a third notice, that is after the FIR part, of course,
Yes.
he says that those 3 years which lapsed is a ground for us to quash the FIR.
And there is no explanation in the FIR.
The delay in sending them the preliminary inquiry report to start up an FIR, to have a FIR lodged, that delay is not explained, is one of his grounds. And the other part he's saying is that since he's the senior most
Yes.
and the DPs are being interfered with by this court, the only other option you had was to have an FIR lodged so that you could keep it under seal cover and not afford him the promotions if he was entitled to the same.
But that is not challenged. No. He has never challenged.
Which
I
part?
have taken this.
That he has not challenged his non-granting of promotion.
No. He's saying that since I am in the line for a promotion, this FIR has been lodged.
Just to house me from
It
the plea.
just to keep my results in a seal cover. That is, those are his only 2 grounds. The delay, why it was sent
Kindly
delayed.
appreciate one thing. Well, to my lord, keep something, some promotional consideration under seal cover. There has to be a charge sheet file, not merely filing
Not
of
a
an FIR.
FIR.
They're not merely filing of an FIR,
Ah.
not merely filing
So
of a.
unless the charge sheet comes out, it
Or
is.
there, if there is a departmental proceeding pending, departmental proceeding starts when the so-called the notice is issued. It was already issued. So if
No, that has been stayed, so that will not be a ground for the department now to, if it is stayed.
if we had the pilot malice to not to grant him promotion, we could have harped on the so-called notice itself.
What we can do is we'll issue a notice to
But
allow
he's
them to
already
come
on-
up with an affidavit.
He's already on my lord anticipatory bail, man.
I have
Ah.
cooperated, my lord.
There is
However,
no-
my lord,
there is
my
no-
problem is that, my lord.
In fact, you were supposed to retire as per the earlier order of this
Correct,
court
my
in
lord.
February
Yes,
2026.
Yes.
What happened?
Now, my lord,
He has
now, my
retired,
lord. Now, my lord, the date, one date has been corrected. My retirement 31st of my lord, March, my lord. They have corrected that. 31st, this month.
31st of March.
Yes, my lord. Recently corrected, my lord, on 21/2/2026.
He could save himself, my lord, because of the procedural impropriety caused by the officer. If my lord peruses page 53 for him,
We have seen that.
on merit, my lord, he has no explanation.
Not the
My lord will kindly see the petition wherein my lord the so-called was interfered with because it was this special was interfered with. It was purely based on a preliminary inquiry report.
Preliminary.
No opportunity afforded. That was a mistake done by the government.
That is-
Paragraph 16, my lord, will kindly see. Page 53. My lord, he trying to give a different interpretation of this, my lord. For the reasons stated herein above, this court is of the opinion that the impugned order of dismissal from service dated so and so is vitiated by arbitrariness and illegality. Very well, my lord. The same is accordingly set aside. Consequently, the writ petitioner shall be reinstated back in service. However, having regard to the
Yes.
peculiar facts and circumstances of the case and nature of allegation brought against the petitioner, this court is of the opinion that the fact of the case do not justify exoneration of the petitioner. So if exoneration is not justified, FIR is justified, my lord. On such technical grounds, without subjecting him to a proper inquiry proceeding. As such, here is the catch, my lord. As such, the department is granted liberty to initiate a fresh proceeding against the petitioner from the
No,
stage of issuing.
In any case, he cannot, one cannot challenge a finding in a preliminary inquiry because necessarily preliminary inquiries are behind the back of the
Exactly. He was not made a
incumbent.
party.
It is only after, so it is only a inquiry to find out whether a disciplinary proceeding is required or not.
Otherwise, my lord, preliminary
he cannot
inquiry is not
challenge.
mandated under any law. If my lord perishes last line, my lord, as such, the department is granted liberty to initiate a fresh proceeding against the petitioner from the stage of issuing notice upon the petitioner to explain his conduct. So
Conduct,
this
yes.
explanation, my lord, came in,
Mm.
which is not mandated under Assam Services Disciplinary Appeal Rules, my lord. It is the show cause and reply. So when we issued it,
But then another issue would come up. There is a recent Supreme Court judgment. This 132025, it was required to be completed within a period of 6 months.
yes, my lord.
Now, the recent Supreme Court judgment, if I'm not wrong, says that unless you ask for extension of time, you cannot go beyond that.
Because there is an interim order passed by this honorable court thereafter.
Okay.
This was challenged. He said, my lord, immediately this was followed by
That period will be subjected.
exactly. Because he is on interim protection.
Yes, we'll issue a notice today
We'll file
My
a
lord,
petition.
my lord,
and
my-
we will observe
Yes.
that there is no charge sheet
Yes,
placed before this court as of
Yes.
today.
correct. My lord.
And therefore,
case should not be made infractuous because charge sheet and the offense is cognizes is
Can they,
taken.
can I direct the additional advocate general to ensure that no charge sheet is filed?
Let the
We cannot do that.
He is under,
We can only observe.
Prayer, my lord.
he's already under interim protection, well, he's in the anticipatory bail. So let the investigation go, mal. There is no scope of quashing, mal.
That
Disciplinary person was not exonerated, mal.
Charge sheet has not been filed. and
that is,
the-
we will record your
Yes,
submission.
my lord.
That has not come before us from any source, it has come from you. We'll just absorb. Heard Mr. D.K. Das, Learned Counsel appearing for the petitioner, also heard Mr. P.N. Goswami, Learned Additional Advocate General and Standing Counsel, Public Health, Engineering Department. Full stop. The grievance of the petitioner is against an FIR lodged on
25, my lord. Page 72, my lord.
252025.
25.
See, the
Yes.
delay acts against you also. 252025 against the petitioner on the basis of a preliminary inquiry report submitted on 28/4/2022 by the then Deputy Commissioner Nolbari regarding misappropriation of government money. Full stop. The Learned Counsel for the petitioner has submitted that the departmental proceeding which had arisen out of the preliminary inquiry had been interfered with by this court on earlier occasions, and presently the fresh show cause notice has also been kept under stay. Full stop. The Learned Counsel for the petitioner has submitted that as of today, the charge sheet in the FIR has not been filed. Full stop. The learned additional, he has prayed for an interim. He has prayed that in the interim during pendency of the this repetition, the further process in the FIR may be kept in abeyance. Full stop. The Learned Advocate General, Additional Advocate General Assam has submitted that the investigation with regard to the FIR may not be required to be kept in abeyance since the investigation is not putting the petitioner to any prejudice. Full stop. This court notes the submission of the Learned Counsel for the petitioner that the charge sheet is to be submitted, and therefore at this stage he has not suffered any prejudice. And therefore, this court is of the opinion that the petitioner has not yet suffered any prejudice. Full stop. Issue notice. The respondents are represented through their 1 to 4.
Public prosecutor.
1 to 4 are represented by their standing counsel. The learned APP, Mr. So-and-so Busha, appears for the respondent number 5. Formal steps are not required. Extra copies to the learned counsel for the respondents within a period of 3 working days from today.
Yes.
List again on. By when can you file the affidavit, sir?
After due vacation.
List again on 22nd of April.
My lord.
22nd of April 2025, by which time the respondents shall be at liberty to file their response to the repetition.
Deeply obliged.
My lord, lordship may kindly observe one submission, my lord.
Ah,
That delay ground may kindly be reflected.
The Learned Counsel for-
More than 2 years, even from the initial inquiry.
at the middle of the order, na? The Learned Counsel for the petitioner has submitted that there is an unexplained delay
Yes.
in lodging the FIR by the respondents. The Learned Advocate General has retorted by saying that there is an unexplained delay in approaching this court against the FIR.
My lord, obliged. my lord.
Deeply
Let both be on record.
Deeply obliged.
Obliged, my lord.
Me please, Lordship.
Item 15.
Lordship, in this case, Lordship, conducting counsel, Mr. M.K. Neog is out of town today. Kindly adjourn the matter.
Have you served the amicus?
Yes.
Are you there? Okay. He wants some time. When do you want it?
Any day also next week.
There's a prayer for an adjournment on behalf of the learned counsel for the petitioner, the learned APP and the learned amicus curiae, Ms. R. Chaudhary are present. List this matter again on 13th.
The up to date status report may be called for.
Huh?
Up to date status report may be called for of the trial court.
List the matter again on the 13th of March. The up-to-date status of the proceedings in the trial court be called for.
Let it be on 18th, my lord.
18th, make it 18th. 18th?
It is from Lakhimpur, so it will take some time.
They scan it and they send it by email now. They don't send hard copies like the earlier days. Yes, 18th. CDA waited.
My lord, I am in 17, Lucio.
Ah.
I am in 17, Lucio.
Yes.
Holding was here, Lucio, with a file. I could not.
After some time.
After some time, Lucio, just after one night.
18. 18.
May I please the lordship? Lordship, we are in the case, lordship, the under section 21C, my lord. Trial is going on. Charges have been framed.
Trial court record ahane.
My lord, TCR is with me.
Yes.
Lordship, charges have been framed under section 21C, my lord, commercial quantity. And so far the seizure is concerned, my lord, it is 276.91 gram of the heroin, allegedly. And the commercial quantity is 250 gram. So far the FIR is concerned, lordship will kindly come to page 15, lordship. The crux of the allegation is that, my lord, there was a Naka checking. One bike rider along with his bike was coming, my lord. They signaled him to stop. He did not stop. Subsequently, at a distance, he fell down from his bike and he was admitted to in hospital, my lord. And thereafter, while he was in hospital, search was conducted in his motorcycle, my lord. And subsequently, allegedly, my lord, 276.91 gram of heroin was seized, my lord. So, Sergeant Caesar.
At the time of the recovery, you were not there.
No, my lord.
You were in the hospital.
As per the FIR, as well as per the SASIT, my lord. And so far the ownership of that bike is concerned, my lord, there is nothing on the SASIT to whom that particular motorcycle belongs, my lord. That is AS25Y8576. And there are 10 listed witnesses, my lord. At the time of till the filing of this application, my lord, none of the witnesses have been examined. So my ground is that, my lord, as on today, my lord, 347 days till filing of this application, no witnesses have been examined. That apart, my lord, the search and seizure was not conducted in presence of the petitioner, my lord. So entire search and seizure becomes doubtful in his absence.
In fact, you should have been left on the road suffering the accident and then search and seizure should be made.
No, my lord.
What is more important, the search and seizure or the medical attention to an injured?
My contention is that, my lord, after my release also, that could have been conducted, my lord, because that bike was in their custody, my lord. Motorcycle was in the custody of the police, my lord.
Yes, sir. What do you say?
My lord, here in this matter, my lord, there is a contraband recovered already his case. SARS frame on, my lord, 16/10/2025. Mainly, my lord, there is the accused petitioner submission before your lordship is that there, my lord, inordinate delay in the part, no PWs were examined. So, my lord, that is the rigor of the 37 will not be there, my lord. And my lord, it amounts to, my lord, that is the violation of the fundamental right. That is the submission. Now, my lord, I have gone through the order sheet, my lord. That is, my lord, as per that, my lord, the charges frame on 16/10/2025. Thereafter, my lord, the fix for evidence on, my lord, the 30/10/2025, 12/11/2025, 26/11/2025, 23/12, 6/1. And my lord, 19/1. Then thereafter, my lord, on 2/2/2026, my lord. That is, two numbers of PWs were examined, my lord. 2/2/2026, my lord. Two numbers of PWs were examined, my lord. I have like marked that order, my lord. And my lord, thereafter, the next date is fixed for 16/2/2026, my lord. So, my lord, regarding the inordinate delay part, my lord, and within the, my lord, month only itself, my lord, these are, my lord, that is my lord, the dates were given by the learned, my lord, trial court, my lord. So at this stage, my lord, because of the inordinate delay, my lord, my lord, our humble prayer before your lordship is that, my lord, it may not be granted, my lord. And my lord, let it be, my lord, because my lord, two numbers of witnesses already being examined, my lord, in this regard, my lord.
How do you bring in 21C?
My lord, 21C is, my lord, that is, my lord, contraband is, my lord, 276.91 gram, my lord, of, my lord, heroin, my lord. And my lord,
Yes, sir. Now that the
250 gram, my lord. 250
PWs
gram
are going on.
yes, my lord.
Lordship, my submission was that, my lord, till filing of this application,
We
that is
understand.
subsequent development, my lord.
No, no, that's now we are asking you on the subsequent development.
Lord, yes, that is the subsequent development.
So now when the PWs are going on,
I have flag mark, my lord. My lord may kindly fail use, my lord. Two orders only. Subsequently, হেৰিখিনি আহাই নাই আপোনাৰ নহ'লে গোটেই এটা হেৰিটো চল্ভ কৰা হ'ল গোটেইখিনি নাই হাতত চব কেছ
you're a Caesar witness. Caesar witness have been. Caesar witness has come.
my
Yes, sir. It is going on at a right pace now.
Lordship, if the Caesar witness have been examined, if their statement is there, my lord, whether they have implicated the. Lordship,
If you want, we can just read out two sentences. Police searched a motorcycle and found under the seat of the motorcycle. And the other one says almost the same thing. He says, police searched the motorcycle and found under the seat of the said motorcycle.
Lordship,
What?
my submission was that, my lord, the ownership of that particular motorcycle.
No,
Motorcycle,
no,
it was
they
not
have,
ascertained.
they have seen you falling from that motorcycle
yes,
and injuring yourself. You were riding it. Whosoever be the owner,
my
that motorcycle was being was with you at the particular point of time. So at this stage,
mistake.
the TCR has been received. And an AVP has assisted this court in going through the scene. Two of the Caesar witnesses have been examined till date. This court finds that the trial court proceedings are going on at a correct pace. At this stage, since the allegations are under section 21C, this court is not. This court is of the opinion that the petitioner cannot be granted the privilege of bail at this stage. Full stop. Accordingly, the bail petition is rejected at this stage.
Obliged, Lordship.
May I please, Lordship. Lordship, today we have some personal difficulty, Lordship. Lordship, madam is for the Lordship.
At the request of the learned counsel for the petitioner, list the matter. On when do you want it?
After 2 weeks, Lordship.
When do you want it? Tell
After
us.
2 weeks?
On 20?
Yes.
20 March?
20th
20th of March.
20th.
Item 17.
Sorry, my lord, that
POCSO, no?
file was not issued. Okay, here basically I am with the medical report. Lordship.
What is the medical report?
Medical report, Lordship.
Just a minute. Ah,
Yes. The FIR, Lordship, was lodged on the day of the alleged occurrence, Lordship, 22, and she was examined on the same day, Lordship. But the medical report is totally negative. Lordship. I have annexed that medical report also. Lordship, at page 11, Lordship, starts from 11. The findings, Lordship, will find at page, type copy, Lordship. Findings, Lordship, will find at page 15, Lordship.
just a minute.
17.
7.
Final.
Can-
Addition affidavit file করতে।
No.
The vote of 15 also file করতে। 15,
Page
Hmm.
15.
27.
Page 50, what did you say, page?
Page 15, Lordship.
Yes.
That is the findings, Lordship, of the medical doctor, Lordship.
Page 1515.
1 5, or 27, Lordship, sorry, I'm sorry.
You can mention the inner page.
Huh?
I'm
He's
sorry.
referring to the inner page, my lord. Not the serial number of the page.
27.
27. Yes, we have seen 27.
Although, per the FIR allegation, Lordship, she was forcefully raped, girl of 16 years on 22nd. This is the allegation, Lordship. And, but she was examined on the same day, but nothing came out in the medical report, Lordship.
You've seen that. Yes, what do you say?
Cannot be, my lord. This is, my medical report is not vital, my lord.
Huh?
Medical report is not vital, my lord, in case of the POCSO, my lord. Let the victim examine first, my lord. The cases, my lord, charges is yet to frame, my lord. The case was fixed on, my lord, 17 to 2026 for consideration of charge, my lord.
Lordship, already 164 days, and as per my instruction, Lordship, that court is lying vacant, Lordship.
That is
Court-
different. As
Trial
per
court is lying vacant, Lordship.
Let the victim girl examine first, my lord.
Have you seen page 21? Page 21, bottom portion. There appears to be some other story.
Yes, my lord, that I have.
Accused is 73 born. Huh?
My lord,
It's more than 52.
yes.
Yes, what do you say, Mr.?
I was able to point out that page 21,
What is page 21?
the last paragraph.
Ah.
Just what to point this.
See, she's bettering her story all the time. Why? It comes on one incident, then regularly it is being done.
I am the amicus here.
I understand. Amicus doesn't mean that you'll support the victim. You'll tell us the law. Hmm?
My lord, Lordship, may I kindly see one aspect of the matter, my lord.
Ah,
The incident is of, my lord, 22/9, my lord.
ah,
22/9/2025, my lord.
Ah.
This is clear from the page number 14, my lord.
ah,
Now, Lordship, may I kindly come to page number 30, my lord. The medical report, my lord.
hmm.
Medical report, my lord. Page number 30, my lord, 24, serial number 24, my lord.
Page number?
30,
Ah,
serial number 24, my lord.
ah.
Little down below, my lord. Opinion, my lord. On the basis of physical examination, radiology and laboratory investigation done on 23/9/6/10/2025, my lord.
Radiology is 610.
Then, my
Date
lord,
of examination is 22, page 28.
6/10,
Huh?
on 23/9 and 6/10, my lord.
Why don't you have
Medical
page
physical.
24?
Page
F-
24 is this.
Date and time of examination?
28, let's say, page 20.
But in page 21, it is stated that she was sent the next day, 23.
Ah,
Next
On
day
the
she was
next
examined.
morning, that is on 23/9/25, I have sent the victim card to POCSO Medical College and Hospital for her medical examination.
a minute. Just a minute.
My humble submission, my lord, since it is a search-cited case, my lord, let the victim got examined, my lord. After that, my lord, Lordship may, my lord, consider this bail application.
No, the dates will tell you if you take up page 28. Page 28, you will find on 22/9 all the physical examinations have taken place.
Yes.
At this point of time, I think we can wait for the the victim to be examined. What does she say to the police?
Status to prove. Yes, already. Okay, consider. Huh?
We'll allow the one of the witnesses to happen first. Hmm? What is this? Who is Munni baby?
Daughter, Lordship.
Huh?
Daughter.
Daughter of whom?
Person, Lordship.
Accused, it's a wife. Not at this stage, sir. Although there are some things we are taking note of, but
Lordship may record
Yes.
my submissions. Lordship.
Huh?
The Lordship may record.
the scanned copy of the TCR has been received. The learned counsel for the petitioner has submitted that although the medical examination of the petition of the victim, alleged victim, had taken place on the date of the incident itself and on later dates also, the medical examination does not reflect any incident of recent sexual intercourse or any evidence of recent injury on the body of the victim, full stop. The learned APP has submitted that since the final form has been submitted, it would be prudent to await the evidence of at least the victim.
And
Before
charges
I-
also yet to frame. my lord.
Huh?
Charges is also yet to be.
And
framed.
the charges are yet to be framed. It would be prudent to await
Lordship may just
before allowing the,
make a observation that expedite the trial. Lordship.
Huh? at this stage, full stop. The learned amicus has also submitted that the records would reveal that this was not the sole incident, and therefore therefore at this stage the privilege of pre-arrest bail may not be granted. Full stop.
Not clear.
Huh?
He's in custody.
The privilege of bail need not be granted at this stage. Full stop. We have gone through the records. At this stage, this court is not inclined to grant the privilege of bail to the petitioner. The bail application is therefore rejected. It is expected that the trial court would expedite the proceedings since the final form was submitted on.
Long back. Lordship.
They'll give you the date.
It's submitted on, my lord, 30/10/2025.
30/10/2025. Huh? Mhm.
Lordship, here, petitioner is in custody for last 59 days. The contraband in question is intermediate quantity, Lordship, 37 grams. And page 9 is the FIR, Lordship,
Mm.
and the FIR was lodged on 18/10. Petitioner was arrested on 6/1, Lordship, and not recovered from his position, Lordship.
On 6/1. Where is that?
He was arrested 9 days, and probably, my lord, statutory period where intermediate is concerned 60 days,
Mm. 2 days?
59 days.
My lord, two accused persons, my lord, they were coming on a scooty, my lord. So on the basis of my lord, secret information, my lord, police tried to stop them, my lord. But
They
they
fled.
fled away, my lord. Then they left the scooty and both the accused persons, my lord, fled away.
Mm.
From the scooty, my lord, this contraband was recovered, my lord. Then one person is arrested, other person is yet to be arrested, my lord. So today is 59 days, my lord. Still we have 1 day time, my lord. So let the matter come up day after tomorrow, my lord. Because investigation is pending to
Lordship
collect the
is,
assessment
in
report.
not placing the other men, 2 men are there. The other men already arrested,
Mm.
and he's the second one.
But that is not clear from the case therein, my lord. Police is
Huh?
searching the other accused
Gotcha.
person, my lord.
Internally arrested, my
It
lord.
is 59 days, Lordship. Tomorrow this mandatory period will be over, Lordship.
Tomorrow?
That is why, Lordship.
Let it be day after tomorrow, my lord.
Lordship,
Because
tomorrow.
till tomorrow we have time, my lord.
Tomorrow, Lordship.
Huh?
Till tomorrow we have time, my lord.
It will be tomorrow. If
Tomorrow.
it's been said tomorrow, Lordship.
The Illinois counsel for the petition has submitted that today is the 59th day in custody. The Illinois APP has sought for listing of this matter tomorrow. List
For
again
instruction
tomorrow.
regarding FSL, my lord.
Huh?
For instruction regarding the FSL report.
Whatever you want to bring it tomorrow. Tomorrow you don't have the charge sheet.
My lord.
FSL or no FSL, chapter closed.
But
21.
Ah,
We must news in court too. I proceed for time being.
huh? What about the respondent number 2?
That's for two names shown, amicus curiae A. Fukon.
Name shown.
Yes. Fukon.
Hey, নাম to didiok, amicus A. Fukon. Huh? To herita didiok.
Phone number.
Item 22.
My lord, item 22, my lord, I need some more time, my lord. I am going through the, my lord, TCR, my lord. Commercial quantity, my lord.
Hmm.
I need some more time, my lord.
After some time.
After some time, my lord.
Let him go through it.
Maybe on tomorrow also, if you Lordship.
Either after some time or you take it on 10th. Your choice.
After some.
After some time.
some time.
23.
May it please your lord.
Yes.
No, here, my lord.
23, my lord, did not receive, my lord.
Hmm.
FIR page 9, my lord. Today, 39 days in custody, my lord. And all the sections are, my lord, lordship knows, it is 7 years and below, my lord.
Where were you arrested from?
I was arrested, my lord, from my house, my lord. But my lord, actually, I was the driver, my lord.
Ah.
And then, my lord, I have fallen sick, my lord. And I have given the vehicle to another person. And I am, with the consent of the owner, I have given, my lord. Now they have alleged that the vehicle has been stolen, my lord. It is written in the FIR itself, my lord.
Truck has been recovered.
My lord, it is
Huh?
written on the night. That information I don't have, my lord.
Oh. Entire vehicle has been sold away.
My lord,
Ah.
it is the allegation, my lord.
So unless you tell us that the truck is recovered, the petrol is recovered, can we
At this
consider?
stage, my lord, I cannot say, my lord. Because no instruction.
Short date, my lord. We pray for a short.
Tell us that it.
And here, my lord, no notice was also served, my lord, below 7 years, my lord. There was no notice served upon me. 35(3) notice, my lord.
Next week, any date?
Huh?
Next week, my lord.
When? Choose a date.
Yes.
We'll take up all these grounds. This no notice under 35.
My lord.
Then we do not know about the grounds. Yeah.
On the forwarding report itself, it is written, my lord, there no notice was served upon me. It's sorted. Like, how?
12th, my lord.
How?
List on 12th of March. Awaiting the CD.
Oblige, your lordship.
24 and 25.
May I please, your
Yes.
So with regard to item 24, this is a regular bail application.
Ah.
The accused persons, they were arrested on 9/1/26, my lord.
Hmm.
56 days in custody.
Hmm.
6.85 kilos of ganja were recovered. 6.8.
For personal consumption.
Secretly was this.
Where is that FIR? You see
Page
the
14.
Even in case that is received, my lord.
Ah.
Even in the Shivratri also, my lord,
Understand.
in Mandir also, my lord, more than 6 kilos is not allowed.
6 kilos in total. Page 14, my lord. Lordship got it. If Lordship comes to the last column, my lord.
Page?
Page 14, 1/4.
Uh-huh.
The third paragraph, my lord.
Hmm.
Mary. On reaching the spot at so-and-so, the police team intercepted one Honda Scooty bearing registration number so-and-so and apprehended one person, namely Suraj Burma,
Hmm.
18 years.
Hmm.
He is one of the petitioners, son of so-and-so. During interrogation, he disclosed that he was in possession of suspected cannabis meant for sale. On search of the scooty, the below noted items have been recovered from the dicky of the said scooty in presence of the witnesses. The seizure, my lord, number one Honda Scooty bearing number so-and-so, one Android Vivo mobile. Then number 3, my lord, 58 numbers of transparent pouch containing suspected cannabis weighing 440 grams.
Hmm.
Including the pouch which has been recovered from the dicky of the scooty. Then, my lord, he led the police team. Next page, my lord.
Mm-hmm.
Page 15, my lord, accordingly maintaining all legal formalities, the police team proceeded in the said government vehicle to the rented house of Jayanto Majumdar, where during lawful search, additional quantities of suspected cannabis were recovered from the bathroom of at the instance of the accused Suraj Burman. During the said search, one more person, namely Abhinash Thakuria, aged 21 years, son of so-and-so, was found present, who on interrogation confessed his involvement in selling narcotic substances under the direction of Jayanto Majumdar. Then, my lord, last part, my lord. Para 3, serial number 3 and 4, my lord. 3 is the same, 440 grams from Suraj Burman. Then, my lord, 4, one transparent polythene containing suspected cannabis weighing 1.185 kg, including the weight of the polythene, which have been recovered by the lead of Suraj Burman. Again, language problem, my lord. By the lead of Suraj Burman from the bathroom of the rented house of Jayanto Majumdar. Then 5, one white color polythene containing suspected cannabis weighing 5.23 grams. In total,
These two are brothers. The petitioners are brothers,
no, my lord.
cousins,
No.
both residing in the same house, doing the same business.
That is a rented premises.
Eh?
That is a rented premises, rented house.
No, that is what we are asking you. Both
One is
living
Thakuria
together,
and one
doing
is
the same business together.
They were staying in the same rented house, man. And daily
Yes.
laborers, man.
It is
Yeah,
pending to collect the FSL report, my lord. Regarding, my lord, the other accused person, Jayanto Majumdar, my lord, that is bail application number 25, my lord.
The next.
I have a strong objection, my lord, because this is the anticipatory bail, my lord.
Yeah,
Regarding the other
anticipatory
bail
bail.
application, my lord, 24, item number 24, my lord.
Hmm.
Wherein, my lord, 2 accused persons were apprehended, my lord, and from their position, my lord, this contraband was recovered, my lord. Let the matter come up on Monday, my lord.
From their position, my lord, 440 grams.
Hmm.
Otherwise, my lord, it
No,
was recovered from
initially,
one
my lord,
bathroom.
initially Suraj Burman, my lord, he was interrogated and searched, my lord.
He led to the Jayanto Majumdar's house.
Yes, my lord, he took him, my lord, to the Jayanto Majumdar house. From the Jayanto
And they stay in the
my
rented
lord,
house of Jayanto Majumdar.
No, my Jayanto Majumdar is also staying in the same premises.
Jayanto
Eh.
Majumdar and Avinash Thakur, they stay in the same house, my lord.
No. But then Suraj Burman and Abhinash Thakuria stay in the same house.
CD
So Jayanto, Suraj and Abhinash all together.
Yes. Not sharing the rented house, sharing the rented premises.
Now this 25 we can reject today. 24 we can keep it for Monday.
Monday, my lord.
Should we consider the quantity, my lord?
This 25 we are not at all interested.
On 24, my lord, lordship may consider the quantity and the age of the accused person, my lord.
You want it on Monday for
Monday, my lord.
the FSL report.
FSL report, man. On that day, it will be 60 days, my lord.
56 days there in custody, my lord. 56 days already.
This is also one of
Considering
offense
age,
against the
my lord,
society.
one is Suraj Brahman is 18 years.
That is why
But that is what is troubling us. 18 and
Yes.
21 years.
My lord,
Every
it is
day
also-
behind bars.
Consider
Yes,
their
my
age, my lord.
Every day behind bar is exposing them to
That
worse
is true.
avenues.
That is true, my lord.
Question is that, my lord, they have also started this business, man.
But considering the age as well as considering the quantity, my lord.
We'll
56.
do it on Monday.
Both the applications are mandatory.
25 will reject on Monday, 24 will consider on Monday. Some amount of here should also be installed.
But there is,
Just too young to get involved in these things. Yes, next. Monday. Right.
26.
You're waiting FSL report.
43 application also.
Ha.
On 31/26.
Well, in this case, Harshit has been submitted, my lord.
Then at this stage also we call for a scan copy and keep the bail petition pending. Lord.
What about the service report on the respondent
Oh,
number
that
2?
I don't know.
My lord, that is pending, my lord.
That is also pending. Let that also come along with the scan copy of the search.
Well, it has been submitted, the charge sheet has been submitted, call for the scan copy of the TCR. When do you want it?
After a week, we take it from them.
On, at least again on 18th.
Yes, my 18th of March.
18th of March, the learned APP shall also have instructions on the service of notice on the respondent number 2.
March.
Please, Your Lordship.
Hmm.
Lordship, in this case, Lordship, the informant was not made party. For as a respondent number 2, Lordship.
Okay. This interlocutory application has been preferred to implement the informant in
Respondent number 2.
PS case number
It is a Lordship, special POCSO case, Lordship. Already.
in
Sir,
DA number 63 of 2026. Full
already-
stop. The learned APP does not object to the implement. Interlocutory application is allowed. The
Not.
opposite party number
Two.
2, namely
Romena Begum.
Romena Begum at page 2 of the IA. So and so is included as the respondent number 2, who is the informant in. You don't write the PS case number anywhere.
Now, Lordship, and it is charged, Lordship, already when witness is examined, Lordship. So POCSO case is here, Lordship.
Informant full stop. Interlocutory application disposed of. In the mail petition you write, today by an order passed in the interlocutory application, Ms. So-and-so has been implemented as the respondent number 2. Full stop. Accordingly, issue notice to the respondent number 2 in accordance with the
Earlier,
just a minute. Why are you creating this confusion? Already there are orders implementing as.
Lordship, and this order is wrongly registered, Lordship, and subsequently I have filed this, Lordship.
No, I don't
Registry
understand.
is not issuing the Lordship, notice, Lordship.
Hmm?
Registry is not issuing the notice that because the informant was not with party, Lordship. But this order is a mistake, Lordship.
322026, informant Rumina Begum shall be made as respondent number 2. There's an order in February.
That time, Lordship.
Registry shall make necessary corrections of the cost title in the application. You should have simply filed an amended cost title.
Sure, that is why, Lordship, I is Lordship.
I had to do what? There is already an order. How can I give you another order?
Fresh notice, Lordship.
Ah?
I mean, we take it fresh.
Okay, you strike out both the orders, you right, in IA number 224, huh? This IA has been preferred. Praying for leave to implead the informant Rumina Begum as an opposite party in bail application number 63 of 2026. Full stop. On going through the records of BA 63 of 2026, this court finds that there is already an order of 3/2/2026 impleading the informant as a respondent number 2 in the bail application. Full stop. By the order dated 10/2/2026, the informant was required to be served notice through the registry to be routed through the office of the PP. Full stop. When there is already an order directing the impleadment of the informant in the bail application, comma, the interlocutory application is rendered infructuous. Full stop. Accordingly, the interlocutory application is closed. Full stop. In the main bail application, you write, there is already an order of 3/2/2026 impleading the informant as the respondent number 2. The order dated 10/2/2026 required notice to be served upon her to be routed through the office of the PP. Full stop. The Learned Counsel for the petitioner has submitted that the notices are not being issued since the cause title does not contain the name of the respondent number 2. Accordingly, the petitioner is directed to file an amended cause title in the bail application within a period of 2 working days from today, on or before 9th of March 2026. Full stop. Upon such amended cause title being filed, the registry shall make necessary corrections to the CIS system, and the petitioner shall take steps for service of notice upon the respondent in newly impleaded respondent number 2 within a period of 3 days thereafter. Full stop. List the matter again on
Otherwise, Lordship, and
11, 12, and then we'll have it on 20th of March, along with service report on the respondent number 2. The earlier orders calling for the case diary. The earlier orders वाला काट दीजिए, उसमें लिखिए the case diary be called for.
Little earlier, Lordship.
Huh?
Little earlier, Lordship.
9th, you'll file your cause title. 3 days, you'll take your steps. That is why we calculated 12. We gave them 1 week.
Tomorrow, Lordship,
Nine.
will file, Lordship.
Tomorrow, okay. Then list it on 17th कर दीजिए.
Published. Deeply published. Published.
Lordship was here as a member.
Huh?
Reason code 2.
Amicus curiae was there. Amicus curiae came and he gone for the elsewhere.
We'll have it at 2.
Yes.
We'll have it at 2. Kindly inform him. We'll have it at 2.
Okay.
Yes, sir.
Lordship, last occasion, DRI counsel was absent today also.
DRI. DRI at us call. We'll have it after some time. We'll give us call. Take it up after some time. We'll have it at 2, Mr. Fukun. Your matter. This one also at 2.
It's also us.
Huh?
Item 50 is also us. Supply item 50.
Item 50 also at 2.
License.
Sir is here.
Already managed. 21.
Huh? 21 to POCSO. Here it 20? One.
Item 21.
My lord, in this case, the notice was served, I think they have not come
Hmm.
to my information. So, my lord, amicus query may be appointed, my lord.
Amicus curiae is there.
There, but yes, amicus query is there, but he has not reported today.
No, he's there.
Oh,
I'm
oh.
appearing today for the first time, I know.
You have not been given a copy?
I've not been given a copy in this
Eh,
matter.
why did you not give him a copy? Could have taken the matter up.
Well,
Otherwise, he has gone through the,
I've just gone through today.
Uh-huh.
Otherwise, my lord, the chip sees there is
They are living as husband, wife. Now what to do?
Yes, they are one,
Anu?
my lord,
No.
my husband, wife.
Huh?
husband, wife, they are husband, wife, married.
Oh, that is.
Mother has filed a withdrawal petition, court has not accepted it.
Ah, yes, pregnancy is there.
Pregnant by delivery is there, already delivered.
See this thing.
My lord, there is a judgment of the apex
Well,
court. The married couple should not be disturbed. This is one aspect. Moreover,
See, it has been lost by some social worker, is it not? Who has lost it?
Fair. Affair.
mother has
Mother.
mother has filed withdrawal petition.
Who has lodged the FIR?
Mother, page 17, kindly peruse. My daughter's name is Moon Kumari Prasad, 17 years, 4 months. And my lord, her application before the session court.
The latest part, application part, that is not in the record, but otherwise, her statement in 193,
What does it say?
She has implicated,
Huh?
She has implicated, this process.
he's on the run.
Yes.
My lord, page 27, kindly peruse. She has implicated at this stage, my lord. Subsequently, now she has delivered a child. Every day she is meeting the jail to meet me,
183.
trying her best to release me.
183 statement to the High Court.
It is adolescent consensual sex, my lord.
On the promise of marriage.
Yes.
No,
Where is the
not
consent?
like that.
Not
Not like that as per 183, subsequent, maybe some,
But Romeo Juliet clause will be also applicable here.
forcefully how Romeo Juliet, she becomes senseless at this time, subsequent development may be there,
But you have to admit that she is she has delivered a child. I am keeping quiet. Relation as husband and wife. But when mother has come, informant has come forward, I think she will definitely change her statement before the court. From my limited knowledge in the criminal much normal. Now only I am praying for bail. We will face the trial if necessary. Consequences will follow.
Ramdev Prasad, informant is father.
Hmm?
Informant is father,
Father, yes.
Ramdev Prasad.
My father has filed application before the court. Today 143 days behind the bar, madam.
Six one two zero two six. What is this bail petition number?
Very part.
No, this is for the additional session judge.
Yes, madam. Rejected by additional judge. He is a probably POCSO under POCSO, madam. He is authorized probably. Page 23.
With the statement which is there on record, sir, can we? Three instances.
Deposition, my lord.
Three instances have been.
My lord, now, my lord, leaving everything aside, can we allow that the child, the baby has come up
She is with her mother.
now because of the mother?
Uh-huh.
I'm in jail, that's why.
She's not raising any grievance. Where is that application you said has been filed before the trial court?
Yes, kindly see, peruse it, madam. Page 26.
Of the petition?
Yes. Petitioner Shyamdev Prasad, that is the father, and Murmur Kumari Prasad, victim, both. Most respectfully state that today is the date fixed for the above mentioned case for filing of the bail objection against the above named accused, and accordingly both the informant and victim have appeared before your honor today, that both victim and informant have no objection on bail against the above.
Where is that order? Where is the order passed on that?
Order is page 23. Relevant portion is that informant who is the father of the victim girl lost the FIR against the accused.
Sir, this petition is of 19/1/2026.
Yes. Thereafter I have come over here.
So where is the order passed on 19/1/2026?
This is bail application page
Huh?
23. Page 23.
How can it be? Page 23.
Yes.
How?
Order 19/126.
Same day.
Same day. And relevant portion is here, my lord, page 24. The informant who is the father of the victim girl lost the FIR against the accused Deep Roy, and on the basis of the said FIR, the case number was thereafter the completion of the investigation charge sheet is submitted under section 6 of the POCSO against the accused Topu Roy. Considering the serious allegation labeled by the victim in her statement as discussed above, no objection petition submitted by the informant and victim cannot be considered for granting bail. Victim and the father, both have, in spite of that fact, does not consider. My lord, even if in the trial also, if she doesn't support it, and this application will stand on the way. Ultimately, it will be acquittal. Now, paramount consideration is the victim and the child. Otherwise, they will suffer. Madam.
What about page 26 and 24?
Yes, my lord, that.
How do you reconcile them?
Subsequently, that this application is there, but without her statement, my lord, under what, my lord, circumstances she has, my lord.
You see,
No, where is that signature of the
Signature,
informant
yeah.
and the? Acha.
Signature of the informant, yes, that is there, page 27, my lord.
I can say.
Mano Kumari Prasad.
What do you say?
Otherwise, my lord, in POCSO case like this, my lord, and not once in this case, my lord.
and save the
in-
child
in-
and the mother.
in-
lady.
Second time when my lord, she becomes my lord, senseless and my lord,
No, those things is
These are there.
before, after
yes.
application. Her mind has been changed subsequently. Her mind has changed. Otherwise, she should not have come with an application. My information is that she is every day visiting the husband in the jail. and weeping that how can I bring you out?
That is what was observed by the Supreme Court. A minor gets pregnant, then she is forced to live with, to live in a married life with the perpetrator.
But I hope when I give them an opportunity, I hope for they are the future of the child and the baby.
But the notice in this case had not been served upon the.
But the application can be treated as an amount of consent, my lord. They filed before the session court. Session court also has perused the application but did not consider, since it is a case of POCSO. But my lord, worst, my lord, you are the very experienced person, my lord, in this criminal case. What will be the consequence of this trial? My limited knowledge, my lord, it is a clean case of acquittal after that. She will not support it. And this application will stand on the way. That's why I pray more permanently, my lord, bail may be considered under any condition.
In unlike the other cases, matlab, in child marriage case, matlab, child marriage case,
Marriage first, pregnancy later.
Here, forceful, sexual intercourse twice, therefore pregnancy, subsequently, this development. So this, both the situations are not.
It is a case of Romeo and Juliet cross. That's why.
No, Romeo and Juliet is when one is a Romeo, one is a Juliet. Here one is a Romeo.
Almost 18 years.
The other is forced to be a Juliet. How can you allow that?
My lord, young boy, they have united, my lord, under the extinct of love and affair. It happens, but everywhere it happens.
Statement is otherwise.
Love is there.
Not there.
Otherwise, how is there love? It can be
As per the
possible.
statement, love is not there.
That was
Mr.
statement hot on the weather. Now,
Mr. Fukon, what is your opinion?
Lordship sees the
Statement.
183. The last part, Lordship will also be taken into consideration. He was absconding also.
Maybe
They were
when
looking
there
for-
was
they
a
were looking for
Christian
him.
case,
If-
my lord,
if there was,
absconding.
There are the
Probably, my lord, after pregnancy, she was fled away. But ultimately, he was caught and he came back and they
he was bound to come back, my lord. Ultimately, he was bound to come back, but his conduct, Lordship will see.
Look,
That part.
I admit the conduct is bad. Now, what is the wrong?
What is the stage now?
Yes, stage is regarding appearance stage.
Appearance stage.
2-3 occasions, code is not there. Code is absent. I have pregnant.
POCSO case is still not as come, my lord, to my information.
Presiding officer not there.
Presiding officer is not there.
When were you arrested?
He was arrested, my lord,
1410.
1410.
Is it?
14/10/25. Today it is 143 days.
I think we'll allow it.
Regarding.
With
That is.
no, with the condition that he would not be in touch with the victim or the parents without the leave of the
Court.
child court. He shall not contact any of them without the leave.
But if they want to celebrate the marriage, then court
They'll
permission.
take, they'll take leave from the court.
Yes.
Now she's an adult.
Yes.
No, adult.
Now she's an adult.
Yeah.
He can do that through the court. Heard
Well,
Mr. S.C. Viswasarana counsel paying for the petition also heard. Mr. K.K. Parasar learned counsel, learned APP and Mr. A. Fukon learned amicus appointed in the matter.
It is.
This bail application arises out of Silchar PS case number 1016 of 2025 under section 64 within bracket 1/69 of the BNS. Read with section 6 of the POCSO Act corresponding to special case number 06 of 2026 under section 64 within bracket 2/332 within bracket A of BNS. Read with section 6 of the POCSO Act full stop. The learned counsel, the trial court records called for has been received. The trial court it is revealed that the trial court is not
Is on leave.
is on leave, and therefore the matter has not progressed much. Full stop. The learned counsel for the petitioner has submitted that the victim and the informant had together filed an no objection for grant of bail to the accused herein before the learned special judge POCSO Kachar Silchar on 19/1/2026. Full stop. The learned counsel for the petition has also submitted that the that the alleged victim and the accused are proposing to lead a conjugal life.
Yes.
Given the opportunity. Full stop. The learned APP has submitted that looking at the nature of the allegations leveled in the FIR and also the statement made by the alleged victim in the 183 statement, the privilege of bail need not be granted at this stage. The learned amicus has also made a similar statement. However, going through the records of the case and the no objection filed by the
Father and victim.
informant and the victim before the learned special court, this court is of the considered view that the accused can be granted the privilege of bail with strict conditions so as not to hamper the trial. Full stop. In such circumstances, this court directs that the accused petitioner shall be released on bail on furnishing a bond of ₹20,000 with 2 sureties of the like amount to the satisfaction of the learned trial court, subject to the condition that the accused shall in no case communicate with either the victim or the informant or the family thereof without specific permission and leave of the learned trial court in case the accused proposes to lead conjugal life with the informant hereafter. Full stop. It is also provided that the learned trial court shall be entitled to call in the informant and the alleged victim in person before the court to ascertain their no objection to the grant of bail to the petitioner. Full stop. Bail application is disposed of. We'll add a sentence. We'll formulate something to show that before they accept the bail bonds, a specific statement of the victim or the informant has to be recorded by the learned trial court.
Only one thing, whether POCSO judge is today joined or not, I do not know. That's why.
You'll have the certified copy of the order tomorrow.
Yes.
And by tomorrow, if the learned POCSO judge does not.
I can give you. I'll telephone a call to lawyer.
Find out. Tell us if there is.
He was absent for few.
Or we'll put it up before the district judge. Session judge.
Now he has joined. If he joined, my lord, I'll tell you.
Just inform the court master. He'll tell us.
I'll tell.
There are 2 more matters. Yes. All of 10 minutes.
My lord, 40, 49 and 50. My lord, is it 21B, my lord, 117 days behind the bar.
49 scan copy has not been received.
Even then, my lord, I am placing you at least 6, 7, 8 judgment, my lord. Where Honorable High Court has granted bail, my lord. 170 days. I am facing the trial, my lord. 5 to 10 years punishment, my lord. These are the orders of Honorable High Court, madam. Coordinate benches.
Gross weight 669, 35 grams.
That was 60 days of custody is already over
Yes,
in the first case.
yes.
Hmm?
But it is charge sheet, that's why.
Hmm?
Charge sheet.
Which one?
That your lordship has taken up.
No. There is no charge sheet.
No, that is not charge sheet. But charge sheet cases also your lordship will get, my lord. Bail has been considered. Because long 117 days behind the bar, my lord. No, it is more than 117 days. Today is, my lord, 5th. It is another 10 days, my lord. 127 days. Why have not added this? I was arrested on, my lord, on 3/11/25.
This one is a student.
Yes.
Charge sheet has been filed. Hmm.
Any condition, my lord, I'm facing trial, I have to face the trial till then. Recovery has been done, everything has been done. Now stage of trial.
Hmm. Less than commercial quantity.
1000 numbers of vials, my lord, and weighing, my lord, 669 gram gross.
In
And-
1000 vials, there is 669 grams. Huh.
And net is 35 grams net.
35 grams net.
Okay, we'll consider it.
Considering the length,
Length of detention and the quantity.
49.
Take it down like this.
Each case is also same, my lord.
Huh?
Another case, 21B. Same. Here I think detention is more. Here detention is 100.
This is an item
23 days.
49, huh? This is an item 49. This bill, this is an application under
1092. The next
section
is-
483 of the BNS for granting regular bail to the accused petitioner who was arrested on 3/11/2025 in connection with Silchar PS case number 1092 of 2025 corresponding to NDPS case number 2 of 2026 under section 21B/25/29 of NDPS Act presently pending in the court of the District and Session Judge, Kachar. The alleged recovery from the petitioner and the co-accused is 1000 vials containing suspected heroin weighing 669 grams within bracket gross and 35 grams net, 2 mobile handsets, cash amounting to 21,070 and 1 scooty. Full stop. The Illinois counsel for the petitioner has submitted that the petitioner has spent 100 and how many days?
128 days.
128 days in custody.
And moreover, my lord, interesting.
And the matter
In
has
this proceeding, they have mentioned Yerba. On that day also have mentioned. Not heroin.
Not
There are two contradictory statements.
128 days in custody. 128 days in custody. And since the charge sheet has been now submitted, further custody of the petitioner would not be required since the petitioner undertakes to participate in the trial under any conditions imposed upon him if granted bail. Full stop. The Illinois counsel for the petitioner has also submitted that while the forwarding report had recorded the Yaba tablets to be recovered, the charge sheet has been submitted that heroin had been recovered. Full stop. Without going into the merits of the submissions made by the Illinois counsel for the petitioner regarding the recovery made, since the amount of the contraband seized from the petitioner was more than small quantity but less than the commercial quantity, and on further consideration that the petitioner has been inside the jail for 178 days and the charge sheet has been filed, this court finds it a fit case to release the petitioner on bail on furnishing a bond of rupees 30,000 with one local surety of the like amount, subject to the satisfaction of the special judge Kachar with the following conditions. Ekhono pa di dibo ha. A BA number 32902025 jikita disi jikita ke di dibo. This person is a local resident.
Local Kachar.
Huh? Okay. Jikita ke di dibo ha.
Next case is the same case number.
Same,
Same case,
everything
same
remains the
accused.
same.
Another accused.
Huh?
Detention is here 126 days.
26 days. Oh, সেইটো তো একে থাকিব গোটেইখিনি বস্তু disposed of.
People of rank.
The affair, Lordship may take note of the affair, page minus 16. Relevant portion is at minus page 18. What happened in this case, minus on 16,
There was an earlier order.
earlier orders of this honorable court, while the search sheet has been minus submitted.
Where is that?
That order is at minus page 35, minus.
35. Only on that ground we had.
Because search sheet was
Ah.
submitted, accordingly I approved the learned trial court below. That is
Where is that affair?
page minus 18, minus. Relevant portion.
Huh.
But the police has seized 298 bottles of Costa tea syrup, from one Arifa Khatun. On 16 7 2025, and upon recovery of that particular amount of Costa tea syrup, she was arrested. Subsequently, the police has arrested the petitioner on 23 8 2025. The basic ground for arresting the petitioner's search, and the petitioner has nexus in selling the said particular contraband. Now, what happened, my lord? While the police has seized, my lord, the police has not considered the drag license which has been issued to the my lord petitioner by the competent authority, because he has the right to sell the kind of articles. So far, that particular contraband is concerned, the petitioner is not at all involved. So for selling as well as transporting any such articles.
No,
Because
but
on
we
the
did not.
basis of
We
the
did not understand. What is the petitioner's profession? What does he do?
He is the drug dealers, under license,
Huh.
wholesaler.
Why is he arrested?
Because on the basis of the statement given by the co-accused, Arifa Khatun,
Saying what, that it was sold to her by this man.
he has collected from the petitioner.
Ah.
But so far the she is made in the shop of the petitioner. Nothing has been recovered there from her. Everything was recovered from the Arifa Khatun. Nothing was recovered from the petitioner. Nothing has been found against the petitioner except the statement given by the co-accused. In type copy, 20 page 21 will be the eligible type copy. Affair.
Yes, what do you have against him? Any recovery made from him?
No, my lord.
His shop?
My lord, here the matter is that, my lord, that is the contraband recovered from one lady, my lord.
Huh.
Now, my lord, during
She
the,
says that this man sold it to me.
yes, my lord,
Then?
during the course of investigation, my lord, she revealed his name,
Huh.
and then thereafter, my lord, he was arrested, my lord. Now, their contention is that, my lord, he is a valid license to, my lord, that is the sale of those, my lord, codeines, my lord. As because he is a, my lord, he has pharmaceutical license and he is wholesale of that, my lord. Now, those part are the, my lord, that is the matter of trial, my lord. Whether, my lord, codeine phosphate, my lord, by dint of, my lord, right now, my lord, I don't have the notification with me, my lord, that, my lord, that is, my lord, on the basis of the prescription, or, my lord, it can be sold, my lord. Otherwise, my lord, that is codeine phosphate, it is
If
used
he's a
narcotic drugs,
if
my
he is a wholesaler,
lord,
then a man has to go to the pharmacy,
my lord,
retailer,
my lord,
show him I need codeine.
my lord,
Then the pharmacy has to go to the wholesaler,
my lord.
tell him that, look, this man needs codeine, please give it to me, and he will bring it and then give it to the pharmacy, and the pharmacy will then give it to the customer. If he's a wholesaler, he'll give it to a licensed pharmacy.
Yes, my
He
lord.
will not wait for
Yes,
a,
exactly, my lord.
is it not?
Yes,
So
my
if
lord.
he's a
Not to
wholesale,
retail, my lord. And that is there.
he has not said that he is giving it in retail. You are not saying he is giving it in retail. You are saying in the ground of arrest, he purchased, stocked, and supplied
Right.
commercial quantity.
Right.
If you are admitting he is a wholesale dealer, matter ends
No,
there.
we are not admitting, my lord. That is the contention of the, my lord, accused petitioner.
So how long does he remain? How long does he remain behind bars for you to find out whether he is a wholesaler or not? How long does he have to remain behind bars?
195 days, my lord, as on today, my lord.
My lord, here in this matter, already, my lord, that is, my lord, charge is already being framed, my lord.
We understand. Against whom? Against him? What is the charge?
My lord, that is, my lord, the commercial quantity, my lord. That is the same charge.
That he has held it without a license.
My lord. My lord, the charge is framed against me, or and not a, my lord. My lord,
So
that
now
is-
during
that
the
is-
trial, he'll show his licenses and all, or he'll go home. Why do you require him behind bars when he has got a valid business for other drugs? Assuming it is not for and not for codeine. For the other things, he's a dealer. From where are you saying that it is that you are a dealer? What is your document?
I have another document, my lord, at page 28, my lord. All the documents have already been seized by the police, my lord. While the seizure has been made in my shop, my lord.
Yes. One Akbar Ali is licensed to sell, stock, and exhibit or distribute by wholesale drugs other than those specified in Schedule C and Schedule C1 and 10. What is this drug? It is in Schedule what? It's codeine. Tell us if does it fall in Schedule C
My lord, that,
or H?
let me allow some more time.
In
the meantime, my lord, I'll make a research.
You
and
have
find out
10
more
minutes.
of This, my lord.
You have 10 minutes.
My lord.
This man is a licensed
My lord.
person. Unless you show that it is an unlicensed thing and anything was recovered from his premises,
My lord.
I don't think he needs to be behind bar to face the trial.
Can it be fixed at 2 months?
All right.
I'll just come back to 2
My
minutes. At 2, 22 at 2.
28.
28. Yes. 28.
8.
Is the CD received? He's on interim.
Interim.
28 city not received, my lord.
CD is awaited.
My lord.
List again on
12th, my lord.
12th. 12th.
Interim order may continue.
Interim continues.
Obliged.
His appeal, they are appeal lawsuit before the IO lawsuit and record their statement lawsuit.
City not received, my lord, in this matter.
CD not received. Interim order continues. List again on
13th, my lord.
13th.
Much obliged.
41.
Lordship, awaiting regarding response from service of notice. However, there is nothing POCSO against me. And therefore the accused number 2 in the FIR.
CD is there.
CD is there already, Lordship. I am on the interview.
Let us see.
Mr. Parasar has gone through this matter. Maybe matter may kindly be timing.
After some time, let him leave Mr. Parasar.
32.
32 থেকে
I want interim bill. CD for people.
You are an interim.
Yes.
This is 30.
2.
CD is awaited. List again on
My lord, 16 match.
16th.
16.
Interim order continues.
33.
CD is awaited. None appears for the petitioner. List again on. When can you have the CD? When?
16 match.
16th.
16. 33 already.
31.
33 has come here. Already at
Mention 32 ka stack out korok.
33 already at
Mention.
31.
Malat here, Malat regarding service of notice, Malat from our office, it was sent on Malat 3rd of February. But we are trying to contact with the Malat Larigat PS Malat, we are not getting Malat. So amicus may be appointed Malat this stage Malat. I have gone
What?
Malat regarding service of notice Malat. It was sent from our office on 3rd of February. To the police station Malat by post. And just today Malat we are trying to Malat contact Malat, we are not getting. amicus may be given Malat otherwise.
No, unless you say it is not, unless you say she cannot be contacted, we will not appoint an amicus like that.
That information.
Because the amicus can only go through the bail petition. Rarely they have an interaction with the. Is it not?
That is there, Malat. Otherwise.
Or just for making submissions on the. We don't need an amicus.
Otherwise, nothing is against POCSO against me, Lordship.
Who are you?
15. I am the accused number 2, Lordship. He is the father of the prime accused, Lordship. The
Why
only allegation is that.
Why the father should be on the run when the son is doing something?
Malat, only the name in the FIR, Malat, otherwise nothing in the Malat. I have seen the statement of the girl also, Malat. Regarding him, nothing, Malat, not a single word, Malat.
You are intent, we'll have one more attempt to have the informant. Not done. When you are protected, you are protected.
No, definitely, Lordship, no problem.
Await the service report on the respondent number 2. List the matter again on the 23rd of March. Additional PP shall have concrete instructions on the service report on the respondent number 2. Interim order continues.
Today also,
Had it been some other matter, we would have.
No problem.
POCSO, we need to make attempts.
No. Supplementary item 51.
51.
Is they received?
CD 51, not 50.
Why? Why? Have it at 2? We had given an interim protection.
Huh?
See, we have given an interim protection on 16/12 for allowing them to appear. Charge sheeted?
Yes, well.
Learned APP submits that the matter has been charge sheeted. None appears for the petitioner on call.
Being CS number, Malat, 16/.
Charge sheet has been submitted by CS number
16/2026, dated 25/2/2026.
Now what do? We make it absolute or we dismiss it?
Malat,
That is the information we wanted.
it may be absolute.
Interim order passed earlier is made absolute. Directing the petitioners to approach the trial court in case of receipt of summons in connection with the charge sheet.
52.
We have taken up steps, my lord.
Huh?
We have taken up steps for responding to although POCSO is involved, but the statement of the victim does not reflect our name, my name, my lord. It's taken up by your lordship in the motion stage, my lord. Where, my lord, another person was arrested, and from the forwarding of that arrested person, it was reflected that my name was taken up because of some influence, my lord.
Service report. No? Otherwise, nothing.
Otherwise, my lord, nothing is against me. Page number 19 is the relevant.
No. You are for you are paying for pre-arrest bill.
Yes, my lord. Victim was, my lord, her statement was taken up by the police and by the magistrate also, my lord.
Yes. What is this page 19?
My lord,
He-
yes.
Page 19, he is an accused. Monwar Hussain is the accused. And the victim says that she was exploited by her boyfriend to make allegations against
My
Monwar
lord,
Hussain.
as per 183 statement also, my lord.
Ah.
My lord, she is a 16 years old girl, my lord. She came with her boyfriend and two other person, my lord.
To make allegations against the
No,
present
two
accused.
other persons.
Ah.
Their physical relation with the boyfriend, all these, my lord, they are there.
Ah.
Subsequently, my lord, when some police cases come out, my lord, the other two person and the boyfriend pressurize her that stay.
Take his name.
My lord, you have physical relation with Manor has rape you, that you gave the statement, my lord. My lord, as per 183 statement before magistrate, my lord, the same has been, my lord, given by the girl, my lord. My lord,
No. Who is this Surman Ali? Her father.
Surman is cousin, my lord.
My uncle's daughter came to my residence.
Cousin, my lord.
I asked the accused to take her to Mini Tajmahal.
Surman, yes, Surman, the other person, my lord.
Then if this Surman is making this false allegation,
But he is the cousin of the victim, my lord.
and the victim says that I gave a wrong statement to Surman.
My lord, as per the 183.
Well, just-
statement,
Is it not?
183, I am just saying, my lord. In Jamul is the, my lord, boyfriend.
Ah.
She, on the day of Saraswati Puja, on 23rd of January, she came along with Jahangir, Saddam and Surman. That three person took her to the my lord, boyfriend house to Gauhati. And that Surman booked a room at Gauhati.
Her own cousin.
Booked a room or boyfriend, yes. In that room, she had physical relation with the boyfriend. But room was booked by Surman. তাৰ পিছত দুপৰীয়া 3টা মান বজাত সেই ৰুমত ওলাই আহোঁ দেন জাহাংগীৰ এণ্ড সাদ্দাম মোক শিকাই দিয়ে যে মই পুলিচৰ আগত ক'ব লাগে যে মনোহৰে মোক ৰেপ কৰিছে মানে ৰিগাৰ্ডিং মনোহৰ
We'll make it absolute. If you have got the CD, we'll make it absolute.
মানে yes.
We'll give him bail. Huh? Heard Mr. M.A.I. Hussain Leonard Counsel appearing for the petitioner. Also heard Mr. A.K. Parasal Leonard additional APP appearing for the state. This is an application under section 482, praying for grant of pre-arrest bail to the accused petitioner in connection with Hatigao PS case number 17 of 2026. Read under section 64(1), read with section 4 of the POCSO. The Learned Counsel for the another APP has received the CD and has submitted that as per the story unfolded in the case diary, the accused petitioner here, accused petitioner herein has been implicated falsely in the FIR by the informant, who was actually involved in facilitating the sexual exploitation of the alleged victim, full stop. In the circumstances, this court is inclined to grant the privilege of pre-arrest bail to the petitioner by directing him to appear before the investigating authority on or before the 11th of March 2026 to participate in the investigation process. Full stop. In the event of his arrest, the petitioner shall be released on bail or released on bail on furnishing a bond of rupees 15,000 with one surety of the like amount to the satisfaction of the investigating authority. Full stop. It is provided that during the period of bail, the petitioner shall not in any manner interact or communicate with the alleged victim without the due permission, without the due knowledge and permission of the investigating authority. Full stop. This court also observes that in case a false case has been found to be lodged against a false complaint or false information has been provided to the investigating authority by either the informant or any other person connected with the matter, comma, the informant would be, the investigating authority would have due regard to the provisions of section 22 of the POCSO Act and act accordingly. If it's a false case, let them also have some A be disposed of. Huh?
Might be lost. This case, my lord, out of 7 years, arrive for 7 years, lordship almost, my lord, 3 years, my lord, not 3 years, lordship, 2 years, 10 months, my lord, have served, lordship. So, IA is, my lord, pending for, my lord, suspension of sentence.
This is the IA.
IA is,
No, we are taking up the criminal appeal itself.
appeal is listed, lordship, IA is along with the appeal, lordship.
What is your ground of appeal?
My
Ground
lord,
of appeal.
ground is, lordship, the suspected, my lord, the contrabands were recovered from a bus, lordship. Inside the bus, lordship. 3 passengers were, lordship, arrested, lordship.
Mr. Bush, are we prepared for a disposal?
My lord, I need some time, my lord.
When?
My lord.
When? Today is a Thursday. We'll have it on Tuesday.
My lord.
We are not taking up the IA only because we tend to dispose of the.
My lord.
We intend to dispose of this criminal appeal itself.
My lord.
Now, if it was in a bag,
My lord.
inside the bus,
My lord.
you must show how it is connected to the.
Yes, my lord. Yes.
How do they connect you with that bag? How are they connecting you to the bag?
Connected, lordship. The bag was recovered from under, from inside the bus. Witness says it is inside the bus, and at the later on said it is under the seat, my lord. Over which the one petitioner was, appellant was sitting, lordship, and another was from the bunker of the bus, lordship. Above that bunker, the person acquitted was sitting, lordship. Now only 2 witnesses were, my lord, examined, lordship. As per IO says that those 2 the seizure witnesses were not, the statements of those witnesses were not recorded by. One witness says his statement was not recorded. Now other passengers, my lord, admittedly, my lord, 20 passengers were in the bus, lordship. Nobody was searched, nobody was interrogated, lordship. No witnesses are there. Only, my lord, handymans, my lord, sorry, conductor and the bus driver were, my lord, projected as witnesses, lordship. Whether they were driver or not, or conductor, there is no identity, lordship. The defense, my lord, has suggested that the driver and handyman
that is what we had in mind for a moment.
The IO did not record the statements of those 2 seizure witness, lordship.
They are saying these are a driver and a handyman.
My lord.
And trial court has said that they are not required to have any documents as driver and handyman of the bus. Is it so?
No, my lord.
So far as you know, even city buses are required to carry their identification regarding a particular bus.
Identity is, my
How-
lord. Inclusive, my
how
lord,
they can
but this, my lord, who will, my
from
lord,
where
who
the
can-
trial
who
court
can
has come to-
identify, my lord.
Huh?
Otherwise, my lord, who can identify?
Ah, who is the
It's
handyman?
the
Who's the
bus-
driver? How
Very
can
crucial.
they've got
crucial thing, my
uniforms?
lord.
They've got iCards.
Yes, my
Eh.
lord. Most crucial thing, my lord, identity itself.
Then their identity is not proved.
This
Have
is
page 13, para 28. And this PW3 says, I cannot specify which bag belongs to whom.
right. My lord, that matter may be fixed for my lord hearing, my lord.
On Tuesday,
On
very
Tuesday,
short
my
point.
lord. Oh, yes, man.
If
Tuesday, my
if
lord.
these are not the
Because
driver and the,
penalty is punishment, otherwise, my lord, no, it is not.
if they are not the driver and the
yes,
handyman,
yes, my lord.
if there is a
Nothing there,
doubt,
my lord.
then they are standing up to say that we saw them carry the bags into the bus goes.
Yes, yes, yes.
Conscious possession goes.
Yes.
As of now, that is what we are feeling.
Bye.
Tuesday, sir.
Loss
We'll decide it. Tuesday.
or hearing loss.
Hearing, yes.
Today it is
It
listed.
comes up in any case. Today we are a bit time constrained. Otherwise, we'd have taken it up. We have to rise at 3:15. Therefore, we are not taking up a full detail. Otherwise, we'll take it up on Tuesday. Don't worry.
Loss. How like that?
10th of March. Huh?
Then 30.
Lordship, we have come up with a petition for invoking the inherent jurisdiction of the Honorable Court
Yeah.
against the impugned order, rejecting our prayer for recalling the PW1, the victim, for
Yeah.
further cross-examination, Lordship. The
Huh.
impugned order is at page 29 onward, Lordship.
Oh. Supreme Court of guidelines.
The only ground shown at page 30, Lordship.
Just a minute.
But this is above 15 above 15 years.
Huh.
The only ground shown has been delaying tactics, Lordship. I am behind the file for last 2 years, Lordship. 16 to 24. Submission of charge sheet, Lordship. I have surrendered before the court, and since then I am facing the trial as UTP, Lordship. Here, in this case, Lordship, I have annexed the evidence of my petitions also, Lordship, which I have filed. We have put the specific questions we want to ask the Lordship. The earlier counsel, conducting counsel in the trial court, failed to even contradict the victim. So for what she has exaggerated in her statement before court evidence, Lordship, from her earlier statements.
These are the questions you want to ask.
Yes, Lordship. At page 23 onward, Lordship. Specific questions we have given, Lordship, regarding the age.
Yes, what do you have to say, sir?
Otherwise, my lord, the authorities of the Supreme Court, so
Hmm.
my lord, the apex court is there, my lord. The deal,
To see?
that is the, my lord, the hearing, my lord, that is the, it may be done, my lord.
It can be done.
It can be done. My lord.
Yes.
Here, my lord, that is the vital question is the age of a victim, my lord.
Not only that, he has specified what are the questions that are required to be answered.
Right.
He's not making an open claim for asking anything and everything under the sun.
Yes,
He has said, I would like to ask these questions.
these questions. And that is to my lord mentioned.
Can it be denied?
Not.
Only, they have stated that, earlier advocates inadvertent mistake, Lord.
No, no, no. You should look at page 20.
Yes, I
This man is
see.
this
This-
behind bars.
Yes, Lordship, but they have setting the ground that earlier advocate failed to put that questions.
Huh? He was not properly instructed because this man was under trial. He's an UTP. He's behind bars. He's not communicating with his defense counsel properly. Now he has got specific questions to protect himself. In his attempt to protect himself, he has got certain questions to ask. Questions are detailed. Yeah. Why should it not be allowed? It can be allowed. But you'll have only one chance.
No.
She appears,
We are
you
behind
take
because
time,
we are ready to pay
and
the
it
cost.
is closed.
For pay cost of the victim coming and whatever the committing court to the court from her place. We are ready to pay, Lordship.
There is no stay.
No
What is the stage now?
argument, Lordship.
When is it fixed?
Next date is most probably, Lordship, 10-3 for NO, Lordship.
Huh?
NO, necessary order.
3-4 on the 3rd of April.
No, sir. 7-3, Lordship.
On the 7th of March, day after tomorrow.
Lordship, date can be, we can request the court that yes, case is pending for order, Lordship. We can give the copy of this today's order, Lordship.
No, pass an order. Why wait? Heard Mr. Swansea, learned counsel paying for the petitioner. Also heard the learned APP and the learned amicus. You are amicus?
Legal aid,
Miss R.V. Bora?
legal aid.
As the legal aid counsel full stop. The prayer in this petition under section 528 read with section 438 and 442 of the BNSS. Praying for modification of the order dated 9/1/2026 passed by the Learned Special Judge POCSO Morigaon in POCSO case number 62 of 2024. Under section 366/376 within bracket 3 IPC read with section 4 of the POCSO Act, by which the prayer to recall the PW 1 for further POCSO examination was rejected. Full stop. The learned counsel for the petitioner has submitted that since the petitioner was facing trial as from custody, and appropriate instructions could not be granted to the defending counsel, the cross-examination of the PW number 1 was not to the satisfaction of the petitioner herein, and thereby his defense has been compromised. Full stop. The learned counsel for the petitioner has drawn our attention to the petition number 3651 of 2025 dated 3/12/2025, where the petitioner had laid down the specific questions required to be put to the alleged victim, PW number 1.
Yes, sir.
To strengthen his defense. Full stop. The learned counsel for the petitioner has relied upon the judgment of the apex court in so-and-so versus so-and-so.
Natasha Singh is there, Lordship.
Uh-huh.
We have coordinated bench judgment and also there. No, Hoffman.
To impress upon this court that allowing the recalling of the victim for further cross-examination on limited questions would not jeopardize the trial in any manner or put the PW number 1 to any inconvenience. Stop. The learned APP has submitted that the provisions of this POCSO Act, where is that provision where she cannot be recalled again and again or put to any harassment? Huh?
Lordship, it is 3356. Lordship.
33.5, na?
5, Lordship. The special court
More
must ensure the
more
child is
specifically,
called repeatedly to testify in the court.
more specifically, at sections 33.5 and 33.6 disallow the recalling of a child witness repeatedly to testify in the court and also to ensure that the dignity of the child is maintained at all times during the trial. Full stop. The learned counsel for the petitioner has submitted that it is not a case of recalling the witnesses repeatedly, but being offered one opportunity to put a cross-examination to the limited questions that have been put up in the application in the petition number 3651 of 2026. Full stop. Upon going through the materials on record and 2025, 3651 of 2025, Stop. On going through the materials on record and after hearing the submissions of the learned counsel for the parties, this court is of the opinion that the petitioner can be granted one opportunity to put forth the questions in cross-examination as has been projected in the petition number 3651 of 2025.
Yes.
Stop. For the said purpose, the trial court shall fix a particular date for the appearance of the PW number 1 before it, subject to payment of such costs as may be determined by the learned trial court to be paid to the PW number 1 for attending the proceedings on that particular day. Full stop. It is made clear that on the appearance of the PW number 1, the petitioner shall be granted the opportunity of cross-examining the PW number 1 and the same shall be restricted to the questions which have been put up in the petition number 3651 of 2025. Full stop. The learned trial court shall further ensure that the cross-examination is taken up on the date fixed by it and shall also ensure that there is no repeated recalling of the witness for any further cross-examination, etc. Full stop. Criminal petition 94, criminal petition is accordingly disposed of. No.
Deeply obliged. Lordship.
Yes, sir. Yes, sir.
Item number 42 is not likely to reach.
Item number 42.
Criminal appeal, my lord, against the
Did
conviction.
we fix it?
Well, let it come next day, because I have been told that your lordship is rising at 3:15.
315 years.
So it's not likely to reach.
Okay.
Next Tuesday, my lord.
Due to paucity of time today, and at the request of the learned senior counsel appearing for the appellant, place this matter again on
Tuesday next.
10th of March. 10th of March.
My lord, I am also having a similar prayer.
In?
Item number 9.
Item number
We
9.
have it on Tuesday next, my lord.
We'll have it on Thursday next. Thursday, 12th.
Item number 8, sorry, item number 8.
8. We'll have it on Thursday.
Because there is paucity of time.
Not on Thursday. We'll have it on Thursday, not on Tuesday, but on Thursday. Is it okay? On 12th. উপরখিনি একে থাকিব? On 12th কৰি দিলো। Thank you. Wildlife protection. All of the game.
10-5.
Okay. All of the game.
22.
Yes, my lord, in this matter, my lord, I beg apology, my lord, I didn't notice something, my lord. in this matter, my lord.
Hmm.
My lord, in the search sheet, my lord, while my lord, that is my lord, that is the contraband were says by the police, my lord. So there are my lord particular, my lord, that is the fancy dial, my lord, that is my lord, codeine phosphate, my lord, that is the syrups were there. Police doing the investigation, three things they taken into consideration. One, from the interrogation statement of the my lord, that is the lady, my lord, the accused one. She stated that she bought it from this person. This is the person. Thereafter, they make a my lord, that is a CDR analysis, where from the CDR analysis, it is found that is my lord, there is a my lord link with that person. This is one. Number two, my lord, there is the contraband which were recovered, my lord. They take my lord from where, from which company it is, my lord, taken, my lord. From that, my lord, during the course of investigation, they found the my lord company from where it is purchased. And after that, my lord, when the my lord investigation is going on, it is found that my lord, the particular numbers of my lord, the codeine phosphate, my lord, that is bought by, that is the present accused petitioners, my lord, from that, my lord.
From the company.
Yes, my lord. All the GSTs
Okay.
and all other things are, my lord. My lord, that is my lord, found, my lord.
Hmm.
So, my lord, even my lord, that is my lord, that is the which is annex, my lord. That is my lord, that is the my lord, that is the wholesale, my lord. That is the license, my lord. Police during the course, my lord, they, my lord, says that also, my lord. That. So, my lord, so now, my lord, there are some material evidences, my lord. That is, my lord, that a contraband which is recovered, that is from a company, my lord. It was, my lord, that is the purchase.
So
And
the
of
process is
sec-
legal.
Yes, my lord. It is from the company, my lord, not from that, my lord, wholesaler, my lord. From the company, my lord. I have flag mark, my lord.
Who has bought it from the company?
My lord, that is my lord, that is the my lord, that is my lord in questions, my lord, that is the pharmacy, my lord.
No, this man, was he involved in the selling?
Yes,
Or in the buying?
in the buying, my lord.
In the buying from the company?
In the
So
buying
what
of
is
the
wrong in
company,
that?
my lord, and that is the my lord contraband, which is my lord
The
recovered, my
company
lord.
sells it to him via the proper GST.
Yes, my lord, proper GST.
It can be tracked to him.
Yes, my lord,
So
proper
how is
GST,
he
my lord.
how is he liable if someone else is selling it? Today I get a prescription.
Yes, my lord.
I buy it from the pharmacy.
Yes, my lord.
I sell it to someone
My lord.
who does not need it.
My lord,
How is the person originally buying it responsible?
My lord, he is responsible because, my lord, what my lord has, my lord, stated, my lord, he is a my lord wholesaler, my lord. He's a wholesaler,
He's
my
a
lord.
legal
She
wholesaler.
stated the name of the wholesaler, not anybody retailer, my lord. The lady, my lord.
She has brought it.
Yes, my lord. The she has, my
How
lord,
did you sell it?
My lord, as customers, he, my lord,
No, you have to give a receipt for that, no?
everything has been given, my lord.
To whom?
My lord, any purchasers who comes to my shop, my lord, I
No.
used to issue my lord.
It is not a shop. You are a wholesaler.
I am a wholesaler, my lord.
You will sell it to?
My lord, so far, my lord,
You will sell it to whom? The wholesaler sells it to whom?
but to the my lord, shopkeepers, my lord,
Not to the?
not to the retail person.
Not to the person. Now this lady says that she has brought it directly from you.
It is the my lord.
How did you sell it?
Yes, my lord.
You are helping the trade.
My lord, no, my lord. That is why my lord, submission is
Hmm.
being such. Now, I have so far that part is concerned, my lord. I have made discussion with the family relatives of the my lord accused, my lord. They have stated that he is my lord, running the my lord, wholesale shop, my lord. And so far the accused person is concerned, she is not way connected with the my lord, accused person, my lord. But although she has stated that she has purchased the said articles from the my lord, present petitioner's shop, my lord. Now he is a my lord, running a business of wholesaler,
We will give you 1 week time.
my lord.
This batch number which has been confiscated.
Everything, my lord.
The batch number.
Yes,
To whom was it sold? If it was sold in the name of a pharmacy, it's a different issue.
my lord.
We'll consider the bill. If you cannot show us to whom it was sold.
At this stage, what happened, my lord?
Nothing.
My shop is, my lord, under the lock and key of the police authorities, my lord.
Huh.
And every document has been seized by the police, my lord. And so far the accused person is concerned, he is behind the bar, my lord. And so far the searching of all those documents is concerned, so for the other family members, my lord, it will be difficult for them because they are illiterate person, my lord. Not so much, very much acquainted with the my lord, pharmacy matters, my lord. All documents are with the police, my lord. With the police.
How can all documents? It will be a computer. Seizure, is it kept under lock and key? His entire this thing. His shop is under lock and key.
As I have been my lord, intimated, my lord. They could not open the my lord, pharmacy.
Yeah, on Monday you have this thing. Have it from your IO. We'll fix it on IO. We'll fix it on Monday. Find out from the IO whether the wholesaler premises is kept under lock and key.
Otherwise, my lord, the matter is already, my lord, search and my lord, charges plain, my lord. The trial has, my lord, commenced, my lord.
That
Trial
will, my lord,
comments, my lord.
Only
Here,
thing
my lord,
is
only I just read it out, my lord, from the charge sheet
rejecting,
itself, my lord.
rejecting it on the ground that it is charge sheeted and this and
It is
that.
not
that
only
is-
that, my lord. My lord, it is a matter of trial because, my lord, that the contrabands, my lord. From the
If
basis
that
of
be,
the
my lord-
contraband, my lord, they find out, my lord, from the company, my lord, the source, my lord, from where it is, my lord, that is, my lord, that the purchase, my lord. And my lord, who am I, my lord? I am the, my lord, that is the, my lord, the wholesale dealer, my lord. So those were, my lord, even, my lord, the fancy rail cough syrups, my lord, the particular numbers, my lord. It is not that, my lord, if, my lord, somebody, my lord, sold something, the one, my lord, bottle is something different, my lord. Here, my lord, the number of bottles is 298, my lord. In the search sheet, my lord, in the para of, my lord, 46, my lord. During the investigation, call details, record serious accused of so and so, and examine. Analysis revealed that during the date of occurrence, she was in telephonic communication with the mobile number of Akbar Ali, so and so, so and so, so and so, so and so. So that is a, my lord, the electronic evidence.
Apparently it has been sold, yes.
Yes, a requisition was sent to the concerned telecom so and so, so and so. Now, my lord, in the next part, my lord, during investigation, details purchasers of the says Costa Tea syrups batch number so and so, so and so, so and so were collected from the Saintify. This is the name of the company where, my lord, that is the, my lord, that is the GST. To that, this particular person's, my lord, from is there. I have flag marked that part also. It was found that Akbar Ali so and so, so and so, so and so of Dhubri has purchased 1800 bottles of Costa Aman syrups to the same batch. On analysis of the CDR verifications of the buyer details from the manufacturing company, my lord, the involvement of the Akbar Ali in the present case was established. Accordingly, Akbar Ali was apprehended and examined. For disposition, the following this. So, my lord, it is in the very, my lord, now trial has, my lord, started, my lord. Let the, my lord, witness be examined, my lord. The already, my lord, charges here framed. Next date is, my lord, 2/3/2000. Was, my lord, last date was, my lord, 2/3/26, my lord. That order is not with us, my lord. And all parts, my lord, my humble
this is
submission before your lordship is that it's a matter of trial, my lord.
So for that, my lord,
Otherwise, my lord, there is the link with that particular contraband, my lord, that is, my lord, well established. Along with the, my lord, that is the material evidences, my lord.
so far my brother's submission is concerned, my lord. My brother has suggested that let the entire trial be my lord, completed. And so my submission before lordship is such that if your lordship is fixed it on Monday, meanwhile, my lord, so for the details of my lord sale as regards to the particular my lord, batch number is concerned, that information is with the police station, police, my lord. And so far my
What your IO has done is, to whom was it sold to?
My lord,
Now, if this man has sold it to a pharmacy
my lord,
and that lady has picked it up from the pharmacy,
my lord.
there will be a connection to the petitioner
My
also,
lord, my lord.
no doubt, because that would be an arrangement through the pharmacy.
My lord.
But if it has been not shown in any documents, your
My-
case gets stronger to detain
My
him.
lord, that part is, my lord, lies upon them, my lord. That this is not the thing I sold to that person. And even at this stage, my lord, when my lord trial comments, my lord,
He has
these
not,
things will
you have
affect
not
his, my
explained
lord,
anywhere
trial, my
how
lord.
that batch number went into the hands of that lady.
So far,
You have
my-
not
my-
made any statement that
Yes, because
the
I have
drugs are
not-
sold only to the.
I have made this statement as because, my lord, so for the my lord, petitioner's contingency search, that he is not at all, my lord, connected with the my lord, accused Arifa Khatun, my lord. Never been sold, my lord, any article, my lord. Bottles were found under the custody of the Arifa Khatun, but how she has got and whether the petitioner has sold it to her or not, so far that part is concerned, the petitioner stated, no, I did not sell it to her.
Where is that file confiscation seizure list? Where is it? Sir. The only thing is, if he's a genuine businessman, why should he suffer?
Yes, ma'am.
I can reject it right away, saying that okay, it's at an nascent stage, nothing doing this and that.
Above, my lord, petitioner has two my lord, less than my lord, 10 years old, my lord. Mother died, my lord, already. The sons, mother, the wife is died, my lord. Two minor sons are there, my lord. They are also my lord, suffering.
What is your factory's name?
My lord.
AJ Drugs.
AJ Drugs and Surgical.
There is nothing on record to show that you had sold it to someone properly. When was it confiscated? What is the date of that arrest?
My lord, 23/8/2025.
There's nothing to show that you had sold it to anybody.
If that being so, my lord, I have not sold the said articles to the my lord, said accused Arif Akadu.
Yes. You have not reported a theft. How did it go out of your godown? How will it go out of your godown then? Inspector of Drugs says you don't even have that shop.
So for this, then I have
No records of the firm were found on the current EODB portal.
then I have to take instruction whether
No license has been issued as per official record.
that has to be my lord, clarified, because my lord, he says that yes, I have the drug license, my lord, on the basis of that I am my lord, doing my business of wholesaling of my lord, medicines, my lord.
You want to come back with some instruction?
Yes.
It says there is nothing. The verification shows nothing. That is the main point now.
I have to take instruction.
Kindly take your instruction. The scanned copy of the TCR has been received. Learned APP has objected to the bail petition filed. Full stop. Learned counsel for the petitioner seeks to have some instruction regarding the license, drug license of the petitioner. Full stop. List again on when?
Next week, my lord.
12.
If you lordship, please, may I, my lord, go to the my lord, TCR, my lord, if you lordship allow me.
With the assistance of the APP, huh? After
Because
3.
it is TCR. Already.
After the court rises, with the assistance of the PP.
Yes.
You look at those reports on the
My drug inspector.
drug inspector. They say there is no shop, there is no license.
If that being so, my lord.
It will be difficult.
Yes.
Then it will be difficult, very difficult.
Yes.
Yes, 4 and 5. What happened?
Obliged.
Aru kiba belag ase jodi?
Yes, Lord. 482 BNSS bail application, anticipated bail application in connection with year number 03 of the 2025, dated 21/2/2026. Kindly look, page number 10, Lord. This is pre-wildlife offense report, page number 10. As per intelligence impute about an attempt to rhino poaching at Kaziranga National Park and Tiger Reserve area by a group of people, a search operation was carried out at Raunamukh basic duty area and able to detain one person, namely Vishor Mili, from his residence. Later, he was brought to the custody of Stone Range, Gomiri Forest Office. As per interrogation, he has confessed he and other accomplices were planning for rhino poaching at Kaziranga National Park and Targa Reserve. Later, two Nongshop had made 12 bore live enumeration 1 mobile phone with one SIM card and one Assamese Gamusa were recovered and seized. This is the wildlife report. And in this connection, four accused persons are already arrested by the investigating agency, and a notice was served under section 30, under section 35(3) of BNSS to the accused person with a request to a direction to appear before the IO on 27/2/2026. And now he is ready, Lordship, to appear before the IO to cooperate with the investigating agency.
Go and appear.
Protection for appear before the IO, Lordship. Interim protection is required.
Why?
Because he have no knowledge about why the police have want to interrogate it, and there be apprehension that maybe police.
It says, we'll allow you a date. You go and appear.
Well.
Huh? Let him appear.
Well.
Yeah, Lordship, another case is.
My lord, in the meantime, my lord, offense report may be called for, my lord.
Another matter is also pending for some hearing for hearing a bail hearing on 24th March with interim.
From the, my lord, same.
Same.
That is a bail petition.
Yeah, anticipated.
That is also anticipated.
Everything on same affair also.
There are some orders have been passed by this court.
Yes, it did not.
By the, my lord, code number
Code number 13
14.
today.
What? Today it was fixed today. Any interim orders, any interim protection granted?
Yes.
Huh? Interim protection granted?
Code number 13, item number, code number 14,
Code
item
number
number 13.
14.
BA
This is
number,
a-
AB number 442 also.
Just a minute. We'll ask you, then you tell us, huh? This is an application under section 482 of the BNSS praying for granting pre-arrest bail to the petitioner in connection with offense number ER/03 of 2025. Dated 21/2/2026 under sections 9, 27, 49B, 51 and 52 of the Wildlife Protection Act 1972. Stop. The petitioner had been asked to appear before the investigating authority on 27/2/2026, but however, he failed to do so and is now before this court. Full stop. The Learned Counsel for the petitioner praised that he would appear before the investigating authority on any date fixed by this court to participate in the investigation. Full stop. List this matter again on 24th, huh?
24th.
On 24th of March, along with
BA number, AB number 442 of 2026.
Huh?
442.
of 2026. Full stop. The offense report be called for. In the interim, it is provided that in the event of the arrest of the petitioner, he shall be released on bail of rupees 10,000 with one surety of the like amount, one local surety of the like amount, subject to the satisfaction of the investigating officer. Full stop. The petitioner shall appear before the investigating officer on or before the 13th
Well.
of March 2026 to participate. Huh?
Yes,
You appear on the 13th, both the
Public,
cases.
public.
Both
Item
the
number
cases.
same.
Both the cases. Same order, huh?
48.
Hmm?
Orders, item 53.
Actually,
there's a conviction under section 8 of POCSO. Sentence is of 5 years.
Yes, PP. Mr. Busho, we required some assistance on the steps on respondent number 2. Huh?
We'll take instruction, madam.
When?
Next week, madam, any day.
There's an IA for suspension.
We'll have it on the 12th.
12th, madam, 12th,
12th?
Any other day apart from that.
apart from 12th.
Then it has to be on 17th,
17, my lord.
on the 17th, allowing the APP to have instructions on the service of notice on the informant, full stop.
My lord.
Earlier also time was granted on 23/2/2026, full stop. PP to take note. Huh?
My obliged.
9 and 10 may be taken up together. This is the check, it's 148 order, lordship.
Hmm.
On the
I
last date,
think
your lordship, I asked
some.
them to
Yes, instructions were called for, Your Honor.
What can you do? Yes.
So, Lordship, the question was whether the Lordship had taken a different view. Lordship had taken that if we can come up with an offer and if Lordship finds it reasonable, then Lordship, without going into the merits, would send back. That was the view expressed by Lordship last time. So, Lordship, our instruction is that she initially said about 1.5. And then at the maximum, when we did some counseling, she says that at this point, it is maximum possible to pay 2 lakh. So that is our instruction. And in the first matter, Lordship, it's a matter of record. And in their complaint also, it's there that the whole money has gone to my husband's account.
But you issued the check.
It was taken by deceit. So that those merits, Lordship did not want to hear on the last occasion. Then, of course, I also don't want to go to that extent. But then.
But it has either to be 20% or it has to be none.
Now, Lordship, so far as this 20% is concerned, the statute says that either it has to be 20% or none. But otherwise, if we see, so I got a judgment of 2023, wherein the Honorable Supreme Court has said that it's not absolute, because a lot of courts were saying orders as if this is an absolute.
They have to take a decision as to why that 20% is to be deposited. That is what you're saying.
Not only that, not only then that is not absolute. Some modification can be there based on facts and circumstances.
Jumbo Mandari or something? Yes. Jumbo Mandari, let's say something on different part, not mandatory. In the Deswal case, it was said sell. May should be read as sell.
It has to either give, either it has to say that you deposit it in case it is deposit. No reasons are required to be recorded. In case it is no deposit, then the circumstances have to be given. Why no deposit?
Why not? Yes.
Is it not? Why not is the circumstance you have to
Why
give?
not was the thing.
There must be an exceptional circumstance.
So here that thing was made out. That in exceptional circumstance, if the court thinks so, some latitude was provided to the court. And especially we have come under inherent power. It's not a revision petition. It's a criminal petition. Lordship had expressed his mind that Lordship doesn't want the matter to linger over here. Otherwise, records were called for, things have to be decided in merit.
No, we at that point, on that day, we were not concentrating on the 20% part. We somehow missed it.
Okay.
In fact, I think I have dismissed a similar case. I have dismissed a few days back. Yes, dismissed one. 20% thing we dismissed one recently.
Because they have to make out some exceptional case, lordship, for exemption.
You want to say that the trial court should reconsider the exceptional circumstances?
Appellate court.
The appellate court, huh?
Considered, lordship, in the order itself has considered that no exceptional case has been made out, lordship, in the inquiry order.
Now, if Lordship.
Elaborately considered, lordship.
If that is so, then Lordship, it has to be ultimately argued on merits. If the argument goes in that way.
Argument on what?
On whether the court was correct or not.
in exercising its discretion as to the exceptional circumstance. Just that much has to be seen at least.
See your entire appeal that the orders of the trial court record has been stayed only in case you deposit the 20%.
Yes, it was a conditional stay.
You have not deposited it, then what happens? We can fix it in the month of April, but the stay is not
I'm
there.
not seeking for a very long time. The only thing is the records. I was given 60 days, and as per the statute, another 30 days I could have got. The statute says that. So 3 months, to as per statute, it is possible. So it has come for the first time on the last occasion.
This was in May 2025.
Yes.
3 months.
So after that,
August 2025. It's over.
After that, this matter has come up on the last occasion for the first time. It is years taking dates or anything. So had that been our conduct, then Lordship would have taken, of course, some view.
No, definitely not. We are not taking that conduct. We are not on that. We are just on. $15 lakhs, 2 cases, na? There were 2 cases. If
There were 2 cases. The check amount was 10 lakh and 10 lakh.
15 lakhs is the
15 and 15 was given as fine.
15, 3 lakhs and 3 lakhs.
3 lakhs.
6 lakhs you have to
6
deposit.
lakhs we were to deposit, and Lordship's as per last order, I have come up with an instruction of 2 lakh we are ready to pay, and the appeal otherwise may be heard in the appellate court. We also don't want to prolong it, but maximum whatever, because without instruction on the finance part, we also cannot say.
Okay. When can we hear it? Not today. We'll have to get up at 3:15. We'll fix it on the 26th of March
26th of March.
for hearing. Yes?
Next Thursday?
Not next Thursday. Next Thursday would be 18th.
All right.
26th of March.
All right.
26th of March.
Right.
List this matter on the 26th of March for hearing.
11 and 12.
10, 9, 10 okay. 11 Duke.
11 and
Yes.
11 and 12.
In both the matters are 9 and 10, yes. In both the matters 9 and 10, 23rd. Yes.
Lordship, here in this case, Lordship, Mr. D. Gogoi is required to present, Lordship. Lordship, here, Lordship, I have received another judgment, Lordship. Passed by this honorable court in my case, similar situated. Completely cover up case, Lordship.
Yes.
Lordship, though I have in the earlier occasions, Lordship, I have submitted the apex court judgment regarding Lordship the quashing of the criminal case, Lordship, while the case is pending for the long delay, Lordship. So here in my case is 8 years back, my vehicle has been seized. So Lordship, till date, no such sheet, nothing has been done. So Lordship, in this regard, Lordship, I have submitted, Lordship, earlier occasions, Lordship, the apex court judgment. It's on record, Lordship. And now, Lordship, today I have received another judgment, Lordship, passed by this honorable court in similar situated positions, Lordship. 8 years has gone, no step has been taken. And Lordship,
After some time, let Mr. Gogoi be here.
M14. May please your
Update হয়ে আহিলে নে? ট্রায়াল কোড রেকর্ড তো আপডেট হয়ে গেলে না কমপ্লিট পেজ তো আইছে না No, has not yet been received. না আহিলে চকচোন it has been received, yes.
Two TCR has been shown to cause list method.
Huh?
Two records of TCR has been shown in cause list method.
Two records.
Two
No, one did not contain the whole record.
My lord. Therefore,
Therefore, the other one.
in this case, my lord, there are serious allegations against the petitioner and some other persons. But in the search sheet and my lord, other particulars submitted along with the search sheet, my lord, there is no incriminating materials against the petitioner to establish a prima facie case for trial against the petitioner. My lord. And therefore, my lord, a discharge petition has been filed. That has been rejected and ultimately charges have been framed. My lord. And that is under silence by the, in this
Yes.
criminal petition.
From where do you say that there is nothing?
My lord, I am for the first time, my lord, your lordship may kindly look into the affair, my lord.
In
It is page
16.
22. 22. my
Have
lord.
you gone through the TCR, sir?
No, I have not been able to, my lord.
When? Because on receipt of TCR, we were supposed to consider the interim.
My lord,
So,
except the informant, my lord, no one says, my lord, anything against the, my lord, petitioner. And the informant himself is the IPS officer, my lord, who made an inquiry. And he simply said, my lord, the petitioner and other persons are involved in the offense, my lord. How he is involved, there is nothing on record, my lord. And there are almost, my lord, 38, my lord, witnesses. No one, my lord, mentioned even name of the petitioner, my lord, in their statements, my lord.
Presently, my trial is going on, my lord. And Lordship may kindly say the, my lord, imprint order dated 11/8/2025, page number 35 and 36, my lord.
Have annexed entire records, my lord, which has been furnished as per my lord, section 207 of PRPC, my lord.
so can we take up this evidence part?
My lord, whether there is a prima facie case has been established by the materials furnished by the prosecution for framing of charge, my lord, for trial of the petitioner, my lord. For considering that issue, my lord, this can be, my lord, examined, my lord. Sir, my lord, my research petition is,
We'll allow him some time to go through the
my lord,
TCR.
and my lord, on 13th, my lord, if possible.
12th.
Well,
12th is a
Sun-
hearing day.
Sunday, my lord.
12th is a hearing day.
Then my.
That is 17, my lord.
Hmm?
17, my lord.
17?
My lord.
List again on the 17th of March, allowing the unit APP to go through the trial court records and make submissions.
For hearing, 7 and 38. Lordship, in this matter, senior government advocate Dinath is going to appear. Lordship, kindly give us another date, a short date.
Well, the information sought for by your lordship is with me.
Nothing on the last occasion, we had made it very clear. 5th, either we do it or you do it.
Lordship, actually,
Except APRO, my lord, all the other departments are getting the pay scale, my lord.
Yes, actually what?
Lordship,
Nothing
Miss
goes to-
U Sharma, who was, would have appeared today, has some medical emergency.
You said additional senior government advocate would appear.
Yes.
Now
Your
you are
Lordship,
going for
on the
Mr. Sharma.
She was supposed to appear, but the matter has been transferred to a senior government advocate, Dinath. However, he has some difficulty today. A short date tomorrow may be given, Lordship.
No. No more short dates.
Everything has been cleared, my lord. So 40 sub-organizations
Hmm?
under the my lord, CIG, out of 40 sub-organizations, my lord, only the APRO is not getting. All the other 39 are getting, my lord.
Find out if Mr. Borpujari is available. Our Borpujari. If he's available, kindly call him. After some time.
Item 39 to 41.
কি ঘটেছে?
Lordship, can it be taken after the next matter? Mr. Nawaz is in between matters, court number 8, your lordship.
No,
Not
we,
just one matter, your lordship.
no, we are here only till 3 o'clock.
Yes, your lordship, I have intimated. The matter is ongoing. He will be here at any moment.
What is the charge? If we need to go through it, then it will not have the time. Hmm?
Lordship can wait till the next matter. I have intimated already.
Ask him if it can be taken up on 17th, 24th.
I'll talk.
Just find out. We'll fix the date. Today, anyways, the hearing completion and order passing will take some time.
43.
Yes. Objection was filed.
Yes.
Hmm? Yes, something. Whether it was commercial quantity or not, and whether the proper sections were being applied was your case.
Intermediate in small quantity.
No, you were arguing whether the correct provisions of law are being implemented or not. Not possible today. We'll have it on 17th.
Lordship.
We have around 15 minutes to go. It will be difficult. On the 17th?
Lordship, the trial is on 10th. On the last occasion.
It is on the 10th. What would be your prayer? What is your prayer?
I have prayed for quashing of this entire charge.
Although an objection is found on record, none appears for the NCB today. Full stop. The learned counsel for the petitioner has submitted that the trial is proceeding and is the next date fixes 10th of March.
It is not necessary.
Yes, sir. Strike out that order. The objections are on record.
I'll get my file.
No, can we do it this way? On the 10th, the matter is fixed. Today, we are running short of time.
Lordship.
We'll fix it on the 17th.
That's fine, Lordship.
On the 17th, we'll allow her to make a submission before the trial court to keep it in abeyance at least till the 17th, when the matter will be taken up for final decision here. She'll make a mention, you inform your persons there
I'll do that, Lordship.
not to pass any orders on the 10th.
I'll do
We'll not record it in the order, but we'll give her the
I'll
liberty.
pass
to
the
make mention.
information.
The objections filed by the NCB is on record. The learned counsel for the petitioner has submitted that the matter is again listed for the 10th at the trial stage. Stop. Today, there is a paucity of time since this court has to rise early. Accordingly, list this matter again on the 17th of March 2026. The learned counsel for the parties shall be at liberty to make a mention before the learned trial court regarding the pendency of this case and its date of listing on the 17th of March. Make a mention, they will not. Hey, to diok, hey. Etu kihot ase? 2023, yes.
Remember
Something
that-
very urgent, huh?
No, remember this matter came up a couple of weeks ago.
Ah.
The issue which we had raised was, my lord, that non-compliance of section 313 CRPC. In so much as, my lord, all the entire evidence of each PW was put in one question to the appellants, my lord. So we have attended
Yes.
that matter, my lord.
The 313 examination has to take place again.
Yes, my lord.
And thereafter, the entire circumstances to be considered and a fresh order to be passed. We'll do it on the 17th.
17, my lord, I have some difficulty, my lord. Another matter is.
Ah,
Can
yeah,
we do
but-
19th, my lord?
19th, yes.
19th.
Due to paucity of time today, as the court has to arise early, list this matter again on the 19th.
I'm deep, sir.
এই বপুজাই সব matter to একটা আর বেলেগ matter চলি আছে
37 and 38.
37 and 38. Upon verification of records, Mr. Barpujari, upon verification of records, it is observed that the incumbents holding the rank of Constable, Havaldar, Head Constable, Assistant Sub Inspector are being extended the benefit of enhanced grade pay in pursuance of the notification dated so on, except Assam Police Radio Organization.
Yes.
How can you deny them?
My lord, that is absolutely, yes, lordship is correct, but my lord, one aspect of the matter, because pay commission had the occasion when my lordship is aware, my lord, when different pay bands are called out, incorporated in the ROP rules. So that pay commission takes into account all the nature and duties, my lord, performed by each and every cadre. My lord. So therefore, my lord, different pay scales have been, my lord, incorporated. Now, during periodical pay revision, my lord, this my lord, increase in, my lord, pay scale was extended to other cadres, even except this one. So therefore, under that circumstances, your lordship, my lord, by order dated 3/2/26 had made a pointed query, my lord, as to whether the incumbents holding a corresponding rank in the sub-organizations, whether or not equivalent to the petitioners, but when they exist concurrently in two sub-organizations, have been given the benefit of 7 pay commission, that is in clause 1.172. So this was your lordship's specific order, and a specific query has been, my lord, raised by the honorable court. When we communicated to the finance department immediately sought letters to the administrative department concerned. That is, my lord, the home department. Now, that whether, my lord, those pay scales were extended to any other rank. To that extent, my lord, that information is still awaited. Now, that will be with regard, my lord, to,
This matter was filed in 2021.
yes.
All the information had to be there within the writ petition itself for us to take a decision in the year 2026. We raised specific queries trying to help.
Yes, my lord.
Awaited. So this will await the appeal. It will await the appeal now.
Appeal, my lord.
We'll close this today, allowing you to submit your written arguments. We'll keep it as CAV.
No,
We'll
my-
deliver
my-
the
my-
judgment, it
my-
goes for an appeal,
No, my lord. No.
either which ways.
No, that will be an extreme view on my part. My lord, what I suggest as an officer of the court.
Mm.
Now, this has come to me just now. A communication, my lord, from the Assam Police Headquarters to the Home and Political Department.
Mr.
Now, my lord, let me take instruction on this one because this should go to the Finance Department because they have directly.
We remember. We remember on the last occasion when we said 5th,
Yeah.
Mr. Saikia had asked for a later date. And we had expressed some anxiety in the matter because it is more than a month. And we'll have to release it on the 30th day.
No, in that view of the matter, I will not be seeking much time. Lordship will kindly accommodate me for 1 week. That much I can pay. Let me take instruction only on this one. What finance have to say, because this ought to have now gone to the finance department. Till the day before yesterday evening, nothing was forthcoming from the home department. Now this has come to me.
Mm.
Let me, my lord, get the instructions from my thereafter lordship would be.
Then we would be acting in a very unjust manner when we forced him to have the matter here on the 5th.
That
Is
true,
it not?
That is true.
We expressed anxiety that day.
Absolutely.
We remember, and we did it because perhaps he was not calculating, I was calculating it a day-wise basis.
My lord, the lordship will also kindly, if lordship may be pleased enough, my lord, to consider my predicament to the extent of only this communication, only to the extent of this
Heard
communication.
Mr. I. Sakya, learned counsel appearing for the petition, also heard Mr. R. Borpujari, learned counsel appearing for the finance department. None has appeared for the home department. Full stop.
Not from home department, but yeah.
Lordship, as that's on behalf of.
What submissions are being made? If I record those submissions, it will be embarrassing. On the last occasion, we recorded that there is none. Is it not?
My lord, I am told, my lord, that senior government advocate D.
Now let us make it more clear to you. Till the last occasion, it was Miss Sharma. Now it becomes the senior government advocate. Tomorrow it will become
Yes.
a little bit more.
My lord, my lord.
Are we to be kept hanging?
My lord. I take it, my lord. I take it.
We do our best to accommodate everybody
No, my lord, I take
from
it.
morning to evening
I take
on a
it.
day-wise basis, don't I?
I take it. I take it.
But there has to be a
Yes.
rekha.
And absolutely, lordship is correct. Lordship is correct.
The matters have been extensively heard, and today the matter was, this court had proposed to close the matter. Full stop. However, Mr. R. Borpujari has made a fervent request, a fervent request that he be granted a week's time to have his instructions on the communication dated.
Communication dated 2/3/2026.
Mm.
Issued by the Assistant Inspector General of Police within bracket administration Assam to the Deputy Secretary to the Government of Assam Home and Political Department. Only to that extent.
Accordingly, list this matter again on.
It can come on 12, my lord, next Thursday. Today is Thursday, my lord. Next Thursday is 12th.
12th of
12th of
March. Full stop. It is made clear that no further arguments
Yes.
on other aspects should be entertained.
Yes.
And Mr. Borpujari is allowed only to have his instructions on the aforesaid communication. Full stop. The parties would be at liberty to file their written arguments for convenience prior to that date.
2 PM was fixed.
We'll take it up at 2 PM. On that day, have someone mentioned, we'll have it at 2 PM. Yep.
I'm so. My lord.
We understand the long corridors.
Sometimes it happens.
Hey,
My lord. It goes against my wish and desire also.
in person or secure. Huh?
Even if I do not want to, my lord, this has come as a sudden surprise to me. And I
The redness shows your busyness.
I'm so obliged.
Yes.
I'm so obliged.
Yes, sir. Yes, Forest, what do you want to do?
I am praying for an accommodation today, my lord.
Huh?
I'm praying for an accommodation today, my lord. The copies of the petition are with Mr. B. Sharma, Special PP Wildlife, my lord. But now, my lord, we will take over,
Lordship,
my lord.
kindly see the last several date, Lordship, they are taking, Lordship. Why they are taking this matter lightly? I am so much. Every occasion
Yes,
they are taking.
take it heavily. Why are you taking it lightly?
Any,
Taking
No,
it
they are taking
lightly.
lightly.
Be heavy.
Maybe-
Be heavy. Show us that you cannot release the vehicle under any circumstances whatsoever. We'd be happy to let you retain it, and in case he goes scot-free, then you would have to give him a vehicle which would be as good as it was 8 years ago.
8 is here, Lordship.
It is in our interest to, my lord, not dilute our powers of confiscation, my lord.
Ah.
That is why.
So when?
Monday, my lord.
Monday. You can have it on Monday. At the request of Mr. Ivo Thakur, list the matter again on Monday. No further time would be granted.
Highly appreciate.
Yes, Duke.
Item 44. Good afternoon, sir.
Yes.
Sir, I'm Dr. N. Rajamarthandan IPS, sir. I'm petitioner in person for this criminal petition number 1599. And also an interlocutory petition also has been filed together with this, sir.
Today?
Yes, sir. Yes.
You have filed an interlocutory application today,
It's club, both are
What is the application for?
for early hearing, sir. Already 9 years old case, sir, actually. And this matter
No,
is,
this is, you filed this matter in 2025?
Yes, sir. May I submitted under 442 BNSS, sir, and later on the Honorable Court advised me to resubmit under 528 BNSS. That is how it is.
Okay.
Basically the criminal petition is seeking for setting aside the impugned order of the Honorable Additional District and Sessions Court of upholding Section 217 of IPC from merely a typographical error in a secondary document, not from the mother document, sir, which is practically not existing. And this has been very much captured nicely by the previous order of the Honorable this Court, sir, on 18th of December 2025, the paragraph 8, sir, while staying the trial of the case, this Honorable Court has more or less given the essence of that particular part, sir. The 217 of IPC is the typographical error, which was
Just
given
a
to
minute.
me by the
218 days said, na?
yes, sir.
Secondly, Spencer committed an offense under 98A.
That is, sir.
Okay. Has used the form prescribed for charge with 2 heads. Charge under 218 and there is no specific charge under 217.
217 is obviously a typographical error in the daughter document, sir. The primary document is the charge framing order. That did not contain any other section other than 218 of IPC read with 98A Assam Police Act. When that was challenged before the Honorable Additional District Court, the court was pleased to set aside 218 of IPC. But what the Honorable Court did was it picked up the typographical error in the charge form, which is an extract or synopsis or a secondary document, a daughter document. And if you can go through that page number 85, sir, which is the charge form, the thing itself is clearly says that the charge is framed under 2 head only. The first head and the first paragraph is dedicated for section 218 of IPC. Second paragraph is dedicated for section 98A Assam Police Act. The concluding paragraph of the charge form also is very clear that I am charged under section 218 of IPC, read with 98A Assam Police Act, in tandem with the mother document, that is the charge framing. Unfortunately, 4 lines from the bottom, a typographically a vague and a non-cogent reference of section 217 of IPC had corrupt in the daughter document. That has been enlarged into your and the Honorable Court also made a very paradoxical order, sir. That is upholding section 217 of IPC and asking the trial court to make it clear. It is a hollow in meaning, a self-contradictory. What is upheld doesn't require to be clarified, or what requires to be clarified cannot be upheld.
such a kind of an order has been made by the Honorable District Court, sir. And that
Yes,
has been.
sir, Mr. Busho. Another question is intriguing us.
Right.
In revisional powers,
My lord.
can the charge be substituted?
Revision power is, my lord.
To substitute a charge, or to say that whether this charge was correctly framed or not.
My lord, on the basis of that, my lord, that is the appellate order. And,
Mhm.
and that part only, my lord, if there is, my lord, in the part of the, my lord, there is a law, my lord, something is, my lord, is found, my lord.
Mm.
Obviously, my lord can.
No. What the court below has done,
My lord.
it said 218 gun. But we find ingredients of 217, therefore substituted by 217. Can it be done? That is the charge is for the the court can give an opinion, yes, that we find 217 is there, but 218 is not there.
Right.
So the charge under 218 goes trial court to find out what is the proper charge to be dealt with. That is what can be done.
Yes.
Can it be said, no, you take up the trial on this section, under this section?
No.
Then you have done what the trial court was required to do.
Yes. That's true, my lord.
That is what I'm saying.
Yes.
You can the revisional court can say yes.
Yes.
This may not be very correct.
My
We find it is more on that line.
My
So look into it, what is supposed to be done, but what you have done is wrong.
My
That can be done.
My lord.
Can you substitute 218 by 217 and say that now you proceed on the trial? So we have done what the appellate court should have done. Yeah, it is just
My lord.
so far as divisional powers are there. And if you have the order at page 85,
The charge form is page number 85, sir.
you have 85?
Yes.
Page 85?
Yes.
Penultimate paragraph. And I hereby direct you to be tried by the said court on the charges under section. You see 217? Now come to the paragraph just below it. Charge under section 288 is framed.
Right.
Okay. So this 217 on the top was an obvious, what he is submitting is an obvious typo. It's a typographical error. It should have been 218. And 218 being set aside in the revision, how could 217 be introduced? By self coming to a
The mother documents are the charge framing order, sir, page number 84. The last paragraph. That is clear, sir. 218. I am charged under section 218 of IPC, read with 98 years. No other section is there.
Huh?
The charge framing order, sir.
Now at page 84, kindly have a look. Accordingly, formal charges under section 218. Is it done? So at page 85, the 217 was a typo.
Right.
Now, we are unable to agree to the extent that 217 could not have been, was introduced despite the typo, because at page 46, a reason is given why 217 is being introduced to page 46. The revisional court said that we find ingredients of 217. Is it within its authority to say under what?
My lord, this petition, my lord, I think my lord, criminal petition, my lord.
He had filed a revision before the session judge.
My lord.
In that revision, the additional session judge goes to say 218 set aside. But we find 217. So try him under 217.
Yes.
The superior court says 217. What will the trial court do?
Yes, ma'am.
Tooth and nail it will try to prove it.
Yes.
Because already the superior court is under an impression that 217 will now come into operation.
Yes.
See the language used at page 46.
Yes.
Mr. Parashar, enlighten us a little bit. What has happened is this. First come to page 80. No, Mr. Busho, you be there. We are just having a discussion. at page 84,
Yes.
first. This is the trial court order, last paragraph.
Yes.
Accordingly, formal charges under 218
Yes, ma'am.
of the IPC read with 98A.
Yes, ma'am.
Done?
Yes.
Now, on the next page, page 85, there is a typographical error in the second and last paragraph. I hereby direct you to be tried on the same court with the charges of under 217.
Yes.
But immediately thereafter, charge under 218 is framed. So 217 was a mistake by the trial court. Typo mistake. Plain and simple. Petitioner goes up in a revision, saying that 217, why 217? I cannot be charged under 218.
Yes.
He makes a
Yes. Yes.
great. Now the the revisional court, that is the additional session judge, it says, if you come to page 46, oh sorry, page 43. Thus, in the above circumstances, this court is of the view that section 218 is not attracted. Do you find page 43? Yes? So it is not attracted. Now see the next paragraph. Let me reproduce section 217. From where? Why?
Yes, ma'am.
Was it not supposed to restrict itself to 218?
Yes, ma'am.
Matter ends. 218 applicable or not applicable?
Not applicable.
Suppose the divisional court, it will not be denuded of its powers if it notices that 217 is necessary.
Yes.
It will indicate that 217 may come in, but 218 is gone.
Yes.
So trial court, please reconsider the charges.
Yes. Again.
Now the trial court will come up with 217 after taking into all the circumstances into view.
Yes.
Is it not?
Yes, ma'am.
But now what the revisional court does is 46.
Yes.
Page 46. Hence, 217 of IP is attracted in the instant case. I am of the view learned trial court should clarify the matter. Why? From where 217 has come in? Who are you to say which is the charge to be framed?
In a revision.
In revision, you cannot do that. Even in appeal,
Then it is a
you would
different
say
thing.
that yes, the charge was wrong.
Wrong.
So frame it under 217, retrial.
Retrial. Yes, yes.
It has to be a retrial.
Yes, ma'am.
He is defending himself under 218.
18.
So once the judgment comes, okay, it was a wrong section, try him under so and so. That can
Yes.
come. In a revisional power, could the revisional court have said, no, I find 217 to exist. So try him under 17. Clarify. How can that be?
Revision.
And you see, charge for offense under 17 has been upheld. There was no charge under 217, sir. This was a minor typo.
Yes.
It's typographical error.
Yes.
While framing of the charges, he never had the occasion to reply to 217.
Yes. Yes.
He was told, look, these are the conditions, 218.
Yes,
What do you say?
All are in 2018. Only in
This order has to go.
only in that.
Shortage of time, sir, today.
No.
You are under protection. You have protection. It is under stay.
Yes, sir, it is, the trial has been stayed, sir. Yes.
We'll take it up on 17th. The 17th, we have some time.
Okay, sir.
17th, we'll take it up on a hearing day.
Very happy to answer.
Try to conclude it. Heard Mr. So-and-so petitioner in person. Also heard Mr. Busha, learned APP. At the consent of the parties, since time is not available today, list this matter again on the 17th of March for disposal.
Thank you very much, sir.
Interim order continues. Yes, sir. You were saying, what was your ground?
Ground lordship 47, 48.
Where is that?
Not sir.
It was not even served.
Not. Even the last occasion, my learned friend is examined the whole record.
No, DRI, DRI.
It was not for.
It was not found. No?
Yes.
Now none appears for the DRI again.
Lordship.
Who appears for the DRI?
There are many councils are there.
But their name also reflected Lordship. in the-
This is item number?
48.
M. Kumari. No?
M. Kumar is for Kibia. Pollaki Chakraborty is there.
Standing Council DRI is reflected. By the last order dated 27/2/2026, the matter was fixed on 5th of March, that is today, allowing an opportunity to the DRI to appear in the matter. The trial court records received do not reflect the presence of a section of a notice under section 47 or 48 of the BNSS. Full stop. The learned counsel for the petitioner has alleged violation of the constitutional rights of the petitioner under Article 22(1) of the Constitution of India. Full stop. The DRI has gone unrepresented on the last two occasions. Full stop. List this matter again tomorrow. Is there any email ID anywhere of the respondents?
No.
Huh?
Council, I will inform, madam.
Copy of this order be delivered to, be supplied to Mr. R.K.D. Chaudhary, learned Deputy SGI, to bring it to the notice of the concerned department. Please tomorrow.
Lordship, our item was number 22. Lordship, it is fixed on 12th of March. So Lordship may kindly change it to 11th or 13th.
Kunal, it's 12 to item 12 to.
That matter, where my lord, that is the drug distributor license was taken.
Tell him it is 12th of March. 12th March. You wanted it on 13th?
11th or 13th?
13th.
13th.
11 করে দিও 13 11 13 বহুত জমা আছে 11th of March.
11th.